Screens light up justice calling from Sweden cold and Great Lakes falling. Educating fools, real talk streaming. Truth and laughter, crime redeeming. Raise your glass to law and jest. Trials not just pain and stress. Teach the world, grind the gears. Through the humor, through the tears. Michigan draw cutting sharp like ice. Swedish fire burns, truth precise. Shot of whiskey, sip of gin. Rules of justice, we begin. Raise your glass to law and jest. Trials not just pain and stress. Teach the world, grind the gears. Through the humor, through the tears. Bang the gavel, crack the screen. Courtroom chaos in between. Wine and laughter, we all bleed. Streaming trials, feeding need. Layers of law, peeling truth bare. Laughs flow wild, do we even care? Chip on shoulder, beer in hand again. Together on this shaky stand. Raise your glass to law and jest. Trials not just pain and stress. Teach the world, grind the gears. Through the humor, through the tears.
All right.
Yay!
Welcome. Monday afternoon. It feels like a Monday morning. How was your weekend, Nick? How was your birthday stream?
My birthday stream went great. It went great. And we almost finished the Wheel of Regrets. Almost.
Yeah, 3 or 4
Almost.
left. I can't remember, but
Mm.
we'll get you there one day.
Yeah, we will. I will have one, I believe, the Swedish Midsummer festivals.
Oh, there we go. I will
Yeah.
be hiking through Sweden actually during midsummers.
Oh, really?
I'm going to be doing the King's Trail.
Oh, yeah. The 80-kilometer walk.
It's a long walk, man. I didn't realize the king ran far from the Danish army. That's all I gotta say.
Yeah, that is the Swedish Vasa race on skis. I think it's 89 kilometers or something of the sort.
We're gonna be hiking a section of it, not the entire thing. But it'll be like a 4-day hike that we're gonna be doing. So we'll be up there because we want to see like the midnight sun. It's way up there.
No, it's not up all the way up there.
Well, where we're going is way up there. It's like almost where Finland and Sweden and Norway all meet. Yeah. It's way up there.
The King's Walk. Okay,
It's the King's something. I might have the name wrong.
Oh, yeah, okay. Because we have one way up north as well. But that's another thing. Yeah, all right. I will spend midsummer here, and then the weekend after midsummer, I will be in Stockholm. And I will, I may or may not have a meetup with a mutual friend who is visiting Sweden.
Oh, all right. There we go. I am, what was I going to say? I can't remember. Yeah, I can't remember. Anyways, well, I'm glad you had a good birthday stream. It was a lot of fun, the parts that I participated in.
Yep.
So, yeah, but today we have day 6. Actually, we're gonna do a little reverse. We're gonna go back to day 5 for a minute because we have cross-examination of the defense's 12th witness. That is Louis von Clem. I don't know.
That sounds like a VD.
Yeah, but the cross has been really bad, and they've been really short.
Yeah, I mean the prosecution proves the defense case in their own cross-examinations of the defense witnesses. They are so bad at this.
They are really bad.
Yeah.
So I gave the state or the defense a lot of flack for their cross-examination. I thought it was weak. The state's is just as weak. But I am uncertain and therefore not guilty. Oh, I gotta do a poll. I'm gonna do a poll in my chat, see where we are.
I think I'm okay. Before closing arguments, where are you?
Yeah, okay. Yeah, where are we on guilt before closing? Because we do have closing today, folks. We do have closing today.
Yeah, as it turns out, they did not need 40 witnesses.
That was so ridiculous when they came up with 40 witnesses. All right. There, the poll has been started for all 4 of you in my chat right now. There's a trial going on that's I
heard there's a trial going on that has a lot of views, but we are not having that one.
No, we are not. Instead, we are doing this absolutely excellent trial. I really enjoy this trial, and this is the type of case that deserves a trial, not that other case.
Yeah,
that other case doesn't even deserve to go to trial. No one should be talking about it. Because it shouldn't exist. This one, on the other hand, this is where trials are necessary. So I am stuck at manslaughter. That video. Yeah, I know that video is rough. That video is rough, but yeah, I don't know. Right now I'm leaning towards unknown, uncertain, so that's a not guilty, right? So, but let's bring this up. Let's go over let's finish watching this witness's testimony. So we finish off with some cross-examination for the rest of day 5, but then I guess it carries over for a little bit into day 6. So we'll get going on this.
Make sure your testimony for science is a business. It's not got science in the name, but it's a business.
Yes, sir.
And business is trying to make money as a business. It's not a nonprofit. Right?
It is not a nonprofit.
One of the things being a business, it caters to law enforcement. I think I've seen you say that one of your largest influences in the law enforcement industry, right?
Yeah, absolutely.
Because that's who your constituents are. That's who you market to.
The answer, since I came on, that was actually something that was a problem when I first came on in 2018. The perception was we only really were marketing to police. One of my jobs as the director of consulting communications was to expand that. And as director of consulting, I've gone to great lengths to expand it beyond law enforcement to civilian, where a lot of our cases now are civilian cases and a lot of our audience is not police. But you're absolutely correct. Historically, before I came into the company, they had a reputation for really focusing on police training. And it's still a large part of what we do. We haven't expanded as much as we'd like yet, but you're absolutely right.
I don't want to take his training course.
Now, part of that being part of your audience, you yourself has described yourself as a cop with a law degree, right?
Yes.
You're very proud of that. You want to be a cop.
I love being a cop. Yes.
Love being a cop. You said cops are one of the good guys, so that's why you want to be a cop.
I don't know if I agree with that statement.
Well, I give them the presumption of regularity, and absolutely. Yes.
Sure. Well, that was one of my other questions because you the website.
Yeah.
Police officers
that's one way of saying, fuck you, counselor.
Yeah, so when we start, we give them, especially in a case like this, we give them the presumption of innocence. That's the first thing. And then we give them also a presumption of irregularity. And then we start to look for deviations from that.
But if you start with the presumption of regularity, that's not unbiased, right?
No, I'm not unbiased.
Okay, wait a minute. So starting with a presumption of innocence is not unbiased. I'll agree with that. But that's the system. The system starts with the bias weighted against the state in favor of the defendant. That's the bias that's supposed to be in the system. He's treating it like it's a negative. What do you mean? You just assume they're not guilty and you work your way up from that? What kind of bullshit system is this? That is the system.
That's the foundation of the Western judicial systems. that the government
And the reason for that
has so much power that you have to go in. No, they got it wrong. Now prove it. Prove me that my presumption of innocence is wrong.
Right. That's the whole thing. Let's back this up real quick. The way he said this.
regularity, and then we start to look for deviations from that.
But you start with a presumption of regularity. That's not unbiased, right?
Yeah,
No,
it's
I'm not unbiased.
garbage. Oh, you should go in here unbiased into a trial. No, you should be walking into a courtroom as a juror with complete bias.
Now,
that's an innocent guy.
Yeah, no, he's talking about the presumption that this company or this particular witness makes when they're analyzing a use of force situation.
Yeah.
But why would you not want the expert to use the same standard that the jury's going to apply?
Exactly.
Right?
Train our police officers, they get background investigations. They're then trained and put into these conditions. That my starting point, just as a community member, is that I can give them the benefit of the doubt. Now, in my job, I certainly see a lot of bad examples of policing, and so they can lose that benefit of the doubt. It's theirs to lose. But yeah, just as a community member, I do give police the benefit of the doubt.
Okay. And you also have stated that Force Science has a reputation that there's not a cop out there that you would not defend, right?
Well,
those are your words.
Yeah, since I've been on, that's not our reputation anymore. We do a great job of trying to explain, even in court or at our conferences. My job specifically is to change that narrative since at least 2018, 2019. It's absolutely not true. There are plenty of cops. We don't defend cops, by the way. We just educate juries and evaluators. But there are a lot of police officers whose cases we review that we do not have anything to say that's going to be helpful to their case. And we make sure that the communities know that and that the jurors know that.
Now, part of the thing you put out, you have a website, Force Science website, that you have articles you put up.
Yes, sir.
And you went on that website. You got 3 of the top articles for 2024, your own articles. Do you get to vote on that, or your staff to try to kiss up with you a little bit?
No, the article selection on top articles is based on the number of.
Let's see. Presumption of regularity. Are we talking about law enforcement officers being the fiber of the justice sitting on the defendants?
Shitting on the defendants.
Oh.
Fiber.
Yeah.
Readers, how many people push them out. There's no people involved. It's really a statistical analysis of how broadly the reach was on it. So there's no voting on it. I would vote for my articles, in fairness.
Sure. But those articles the first one was homicidal empathy, an evolving threat to police officers. That was what you wrote.
Right.
Next one was officer created jeopardy, a legal theory that threatens effective policing.
Absolutely.
The expert trap, protecting police from unreasonable expectations.
Yes, I think that was the Michigan.
So those were all yours. Those were all your articles. Those were
Let him finish.
Protecting police, threats to police, threatening police, correct?
Yeah, and those concepts
that's
against police officers.
I didn't need that. I just correct. Didn't ask you to explain.
You want to rephrase it? I want to answer them, but go ahead.
Yeah, that wasn't my question. My question was those were the 3 things the 3 articles that were there are all about threatening
He's
police,
so angry.
Police, how to save police, essentially. Correct?
Essentially, no.
So
if I can elaborate that, yes,
I do believe that
this is not your
prosecutor is asking open-ended questions, and then he ends it with correct.
Yeah, I mean, I get it to some extent. He's asking a yes or no answer. And so, isn't this what you're doing? The answer is no. And then this witness wants to further explain, and the prosecutor's cutting him off. That's fine. I get that. I just like the way
he does it.
Yeah, it's
the
way
so annoying.
Yeah.
Just talk.
Hi. Hello.
Same way that Professor Stone was allowed to answer every single one of Mr. Verbulo's questions as a long answer. So at least let him finish his answer, please.
Right. He's going beyond my question. I'm asking a simple yes or no question, and he wants to pontificate. So
essentially, no. Is my answer.
Is the video feed choppy, folks?
The video feed is choppy?
Yeah,
No?
from the court feed for me is very, very choppy.
Oh, I wasn't watching it. I'm building a Lego leftover from Saturday. I'm just listening. I'll watch.
Yeah, it's very, very.
It's smooth on my end. You were glitching a little.
one of the other articles in 2024, maximizing the officer involved record.
It's a little choppy. Really? Is it choppy for you all? Huh.
lower the resolution on the video feed.
In 2024, correct?
Yes.
You need to look at it? I can show it to you if you want to look at it.
Yeah, I'm assuming you're pulling these from the website?
Correct.
Yeah. This is what year?
Nothing is on my end.
I don't
fine.
think I wrote that one though, but
You
yes.
did not write this one. But part of this, the big interview is officer involved shootings. That's what the big interview is talking about.
Let me know if it
I would
continues.
consider that a big interview. Yes.
Sure. One of the things they talk about in the article is perhaps the optimal solution is to conduct face-to-face interviews as part of the attorney-client preparation phase, where nothing is generated during the unclean recollection process will be discoverable under the attorney-client privilege. So you're advocating, your article's out there saying police officers should interview their attorneys, go through it once before they do an interview with the fact finder. Is that a fair statement?
That's not my article, sir.
Wait, so he's giving advice to police officers the same way attorneys give advice to police officers that says don't talk until you lawyer up.
Yeah, and it's not his article. It's an article on the website. So yeah,
right.
Well, but you're the chief communications officer. Buck stops with you, right?
I am the editor, but I do not write every article that goes in there.
But aren't you responsible for what goes out on your website? You're saying you're not responsible for stuff like this?
I will not adopt every sentence that an author writes, particularly if I haven't read it. I may very well agree with the statement, but he's only providing me a small snippet.
So do you agree with the statement? That's the natural follow-up.
Geiselman or Greenman, yeah. So I can't adopt everything Greenman said. Oftentimes when we publish stuff, it's basically for the industry to consider, and they'll decide whether they agree with it or not. We're not endorsing everything we publish. We find it interesting for the audience, and the audience can read it and adopt it if they choose. Much of what goes out, I do agree with, but without reading specifically every sentence, I don't know that I agree with everything Dr. Greenman said.
Well, this is another one in your website. It's from 2018, but it's still on your website. Veteran attorney cites 10 ways to lose police lawsuits.
No, see, mother knows best, so she doesn't find it
This is
choppy.
before I worked there.
Before you work there, but it's still on your website.
Well, not
you can't distance
anymore.
yourself from something you're the boss of, can you? And just say, you say you're trying to put good information out for police on your website, right?
Hi, Mama Helm.
Yes. So if you got bad information out there, you probably want to take it down, don't you?
No.
No.
You want me to explain that?
No, not really. So we talked about Lexipol. Lexipol is Bruce Pratt. Was that the CEO?
No.
Okay. He was not the former CEO and co-founder of Lexipol.
He was a co-founder of Lexipol, an attorney out in California.
Okay.
Yes.
But did you know him? Because you said you worked for Lexipol, right?
I know Bruce Pratt, yes.
Okay. So you worked with him?
He did not work for the company.
This prosecutor gets just enough information
One of the
wrong
articles
to
in
be
this article,
frustrated.
he talks about how to save police from lawsuits and it's how to clean up injured suspects before photography.
Yes.
Okay. Bloody pictures of suspects injured by police don't help your case in civil court.
Correct. He said that, yes.
He said that, but this is a publication on your website that you're sending out there.
For Science?
Yes. It's do you not see? Is that the FS right there? For Science.
Oh,
take a
from
look
Chuck
at it.
Remsburg. Okay, that's Chuck who wrote that.
Okay. It's out there on your website. Focus closely on the actual injury. Get him to smile for the camera if you can. And don't include pictures of bloody gauze. That's on your website about how to handle people who are injured by police in incidents?
It apparently is.
Do you have a problem with that?
Thank you. In fact, that was the specific issue that Bruce Pratt and I talked about, and I would agree that that's absolutely inappropriate. It was one of the few conversations I had with Bruce Pratt. The reason these things are on our website is because if you look at Force Science News from the beginning of 2000, whenever it started, there's hundreds of articles there. And one of the things that we do like about it is almost an encyclopedia of looking where police was, what has evolved over time, what has stood the test of time. There are a lot of articles back there that we would look at now and say, yeah, that's not how we do things today, but we maintain that library to show an evolution of policing, and it's very effective for that. So there are a lot of articles that we could sit here all day and I could go, yeah, that's not one I would agree with. I don't think it reflects modern policing. However, we leave those in there because it is an amazing library to look at the history of policing through that time frame.
So out of hundreds of articles that span decades of time and police procedures, this prosecutor is cherry picking ones and then presenting. Yeah. Okay. Yep. Sounds about right.
Oh, you're saying 2018, veteran attorney cites 10 ways to lose police lawsuits. That was 2018. But in 2024, we have evolving threats to police that you wrote, legal theory that threatens effective policing, and protecting police. So where's the evolution there?
The evolution I'm talking about is a much broader from police practices and legal approaches and how the law changes over time, how technology changes over time. That's the evolution I'm talking about. You're looking at a small snippet of articles that I don't think I wrote and were probably before my time.
The 3 from 2024 that you wrote those, you admitted those. The 3 the last ones I mentioned were your articles. You wrote those. You
My
admitted that.
articles are great. Yes, I adopt those.
Okay.
Like that.
Part of this, we've talked about it a little bit before, but Force Science is primarily law enforcement officers who are or former law enforcement officers or actual law enforcement officers that are actually employed as on staff. Correct?
I don't know that that's we have 1, 2, 3, 4, maybe 4 of 8 people, or actually more than that. So 1, 2, 3, 4, 5. The answer to that's no.
Okay, I went on the website. We can pull up what we need to.
Well,
You got five staff instructors, correct?
Oh, you want staff instructors? or
Staff
employees?
instructors, 5. Okay, let's go staff instructors. These people are instructing 5 of you, right?
That sounds right.
Okay. Mr. Lewinsky, he's
Never-
not law enforcement.
Never police.
But the other 4 are. You and there's 2 other commanders. The other 4 are former police, correct?
It's likely. We definitely are looking for highly educated former police officers to help educate the population we're interested in. Yes.
And then you have 19 partnering instructors. 9 are retired police, and 1 is a lawyer, Laura Scary, and her work was defending police officers in civil and criminal suits. Is that a fair statement?
They have a lawyer on staff whose name is Scary.
You work with her, don't you? I mean, she's like,
That's a great name for a lawyer.
I like that. So the purpose of cross-examining a witness is to confront them with an alternative theory of facts, right? Or it's to discredit them, so that the jury thinks less of the facts that they presented on direct. So especially when with an expert, right? What you're trying to do is you're trying to discredit their testimony by challenging the basis for it, or their expertise, or their knowledge, or showing some sort of bias or something like that. Is any of this doing that? I'm not feeling it. I'm feeling more badgering.
He's so angry all the time, and the guy just sits there and smiles at him, probably making the prosecutor even angrier.
See, that's the thing, is like, I'm not necessarily on the defendant's side in this case.
No.
And I'd be willing and open and kind of encourage myself to find this guy guilty, because I don't like bad cops. And I don't like even good cops are always bad. So I'm inclined to, like, I want to find this guy guilty, but this isn't doing it for me.
he's listed on the website as a staff instructor.
Yeah, to understand, I don't work with any of these instructors. I mostly teach them. I say I don't work. Nicole Flores and I teach quite a bit. The rest of them are off teaching classes. I'm the director of the consulting division. The classes I teach by myself or maybe with Nicole. Every now and then I might partner with one of them, but I'm not part of our what I call off-the-shelf training programs. So who's currently teaching? I'd have to look, and I might be surprised at who our new staff is as well. But if your point is, do we have a lot of former police officers? The answer is yes.
Now, even though Mr. Lewinsky is not a law enforcement officer, he was inducted to the National Law Enforcement Hall of Fame in 2023, wasn't he?
I think it was a lifetime trainer award. Yes.
Okay. You just gave a presentation at the National Law Enforcement Hall of Fame induction ceremony, didn't you?
Yes.
That was just a few weeks ago.
It was.
And that was in partnership with Virtra. I heard from, is that how you say it? I can't say that. I'm trying to say
Virtra.
Virtra.
Yeah. Okay.
That's Lon Bartels. That's his organization.
Lon Bartel. That's who he works for. He was not part of that training.
Right. But you've trained with him in the past, though, haven't you?
Lon?
Yeah.
Yeah, as often as I can. Yes.
As often as you can. How many times have you trained with him in the past?
Taught classes together, maybe 3 or 4.
Okay. Done other presentations though with him, which I heard about the SHOT Show that you did with him.
That's one of them. Yeah. What we try to do with Virtua is bring their simulator in. So we like to get the community into the simulator so that they can experience what police officers are. That's what Virtua does. So we bring them in as often as we can because they've got amazing technology.
So I'm interested in taking classes with this guy.
One of the things
I know,
is
I kind of want to as well.
Consulting group for Force Science, right? So one of the things you do, I've seen it on just about every podcast, you kind of give your plug for your podcast. Hey, you've been involved in an incident.
This is an advertisement.
Send it into here. We'll talk with you. Make
This
sure
is not
your
a
attorney's present, and
cross-examination.
we'll go over your
He's
case. That's
making an ad.
That's what you do, correct?
Yeah, that's a pre-consult process.
Pre-consult process. And you want to make sure their attorney's present so you don't get subpoenaed, right?
It has nothing to do with the subpoena. It has to do with there is no attorney-client privilege between me and the officer or the civilian who's involved in the incident. So their attorney needs to be present so that they can protect that relationship and the disclosure. Otherwise, essentially not able to tell us enough information that we can have an intelligent conversation. So as a protection for the people calling us, we want to make sure they know, hey, when you call us, make sure your attorney's with us. So that way it's a privileged conversation.
So you can't get subpoenaed to whatever they tell you.
Well, I can still get subpoenaed, yes.
But you can't tell them anything. You can't tell anything if there's an attorney there. There's attorney-client privilege. If they're not there, you're free to talk to anybody about what happened.
Right.
How is this a
No,
bad
that's not-
thing?
We still have our own confidentiality. So we will, if there's no attorney-client privilege, we're still.
I'm not sure what he's getting at. Like I said, how is this supposed to discredit the guy?
We have to disclose it. Of course we will. But we still have a professional confidentiality agreement that we're not going to tell people about those cases.
Now, in terms of that consulting, isn't it true that you've said 98% of the cases you see in Force Science are absolutely professionally well done cases, officers not at fault?
Yeah, they fall within a reasonable range of options. Yeah.
So 98% of the time, when somebody calls you, we want to consult with you. 98% of the time, the police officer is correct.
Overwhelmingly, police officers across the country are correct in their decision making. I don't think you'll find statistics that disagree with that.
That's almost 100% success rate for any profession. That doesn't strike you as a little bit odd?
No. I mean, 98%. I don't have an exact percentage, but I'm telling you,
those are your words.
We see, right?
But that, I'm just quoting your words. It was on one of your podcasts. Law Enforcement Today, choir practice. Some guys, you have a bunch of bourbon in the background. Two guys.
I kind of want to watch this podcast now.
Are absolutely professional, well done cases. Those are your words.
Yeah, that sounds about right.
What kind of put you on the map was a 2000 article in Police Marksman. Why the subject is shot in the back. That was kind of one of your big articles that kind of put you on the map, didn't it?
Not me, no.
Well, okay, you're correct, but Mr. Lewinsky, your founder. That was one of his big.
Bill wrote that.
Okay, but that was one of the.
He keeps trying to attribute articles to him that he never wrote.
You're aware you're heavily criticized in a number of different courts for science, isn't it?
I'm not.
You're not, but Force Science is. I got a case from Federal District Court in Florida. Force Science is widely regarded as a purveyor of unreliable pseudoscientific analysis engineered to justify officers' use of force. Its studies virtually are all non-peer-reviewed, and none of them have been published in scientific.
I believe that, and I'm not putting a lot of credit in this guy's testimony, from my opinion.
Ethical duty of candor to the court. I'm sure you've looked and seen that there's over 30 peer-reviewed studies on our website in some of the highest rated journals in the industries. So whoever advanced that position to the court was essentially lying to the court.
It was a court's opinion. You gotta take a look at it.
I don't need to. I've seen it.
He already said it wasn't him. It wasn't on this.
That's actually, I'm sorry. Yes, ma'am.
No, that's fine. We'll move along. You talk about going to universities, Cumberland University, to train kids, train the kids at the universities, correct?
There were kids there. That one was actually open to community and politicians and law enforcement as well as the students.
But you've had, it's always a bad thing, and we're going to bring up Ohio State University in Michigan, but Ohio State canceled trainings because
we're all way
some of the
louder.
classes where attendees could learn how threatening suspects can be shot in the back by a well-trained officer.
Everything is auto set.
Decision. So Ohio State canceled the presentation there, didn't they?
They did.
You've been criticizing the New York Times and other mainstream media, but you're okay with that because that means you're over the target, doesn't it?
The New York Times was before. It was 2015. It was basically an opinion piece. The author was given an affidavit to demonstrate that what he was putting in the opinion was incorrect. His response to us was, it doesn't have to be correct. It's an opinion piece. There was a lot of fabrications in the opinion piece. We sort of let it go. And if you want, I had to actually research this because it's well before my time. The New York Times opinion piece was ultimately created by people who oppose us in court. So if we're effective in court in educating juries in a way that's inconsistent with their theory of liability, they're going to write opinion pieces that are unfavorable to us. Yes.
And one of the things you do is you use this testimony to go out and then talk to other police officers. You testify in court and then you give presentations about what happened in court, don't you?
We do. That's a feedback loop, so we can get lessons learned, understand what was important to the jurors, or what sort of arguments the opposing sides were making, so we can sort of educate the industry.
So you did talk in Michigan, the Police Officers Association of Michigan, October 10th of 2024. You talked about officer facing 48 years, six others charged, and you talked about your experience in Colorado when you testified for a police officer, correct?
I don't know that. Was that a presentation?
Well, that's what we got. It's a webinar, highly anticipated webinar.
Oh, this was at Caliber Press. That was not.
Yeah. See, I think everyone, at least, I mean, I'm kind of getting past all this police procedure stuff. Remember, this guy's called to rebut what the state's expert said as far as standard police procedures and things like that. And so the prosecution's trying to discredit this guy's testimony, but it only goes to the weight of something that I don't care about anyways. At the end of the day, was the officer in imminent fear of great bodily harm or death at that moment he fired that gun? And I don't know. Right. And so I don't want to say guilty because I don't know. The state still has its burden. So that's where I'm at. Is it possible? Yeah. Would I be scared? Yeah. Would I be exhausted? Yeah. But, so that's where I'm at.
Well, it's to the Police Officer Association of Michigan, though, but
They were Caliber Press is one of the largest police training organizations. They wanted to do a webinar to discuss the facts of the case that they were interested in, and then found out we were involved with, and so they hosted a webinar. It looks like they were advertising that webinar.
but you talked at it.
I was on that.
You were on it. You were the star person. It's, Vaughn and Jim will dive. Jim Glennon. Vaughn and Jim will dive deep into the tactical and legal implications of the case. So you talked about it. You went to the police on a webinar and spoke about it, right?
Yeah, this was a high-profile national case where Caliber Press itself didn't understand the facts of the case. So they brought in somebody who was familiar with the facts. I got permission from the defense team to discuss the case as part of educating the community on what actually occurred in that case, because the media and the facts that were being distributed looked nothing like the reality that the officers were experiencing. And
Is
so
this
We've
seen Chauvin?
We've seen that before.
Is this Chauvin he's talking about, or Ken
I
Porter?
think so. Yeah.
It's one of those two, because those are the high-profile ones that he's been on.
Of that particular incident.
It's also one of the ways you can kind of promote for science, right?
Yeah, everything we do that has force signs and name behind it is a promotion for sure.
Well, not only that, but when you go, just about every time I've watched your podcast, one of the plugs is after you say we're consulting, you advertise, hey, come be a.
How many hours of this guy's podcast do you think the prosecutor watched?
I don't know that I do that enough, actually. My marketing guys tell me, hey, don't forget to tell people about our training classes. So oftentimes when I do a lot of public speaking, I try to remember to give those advertisements, those plugs for the training that's going on. We think we have a very good product that's important to the community and to the attorneys, and we want to make sure they're aware that those products exist so that they can take advantage of them.
And $1,600 a person, that's one of the ways you pay your bills as a business, isn't it?
Yes, and that's incredibly low. It's a week-long class. That's it's a good investment for the individual officers for sure, but it's actually probably worth quite a bit more than that.
Oh,
And
nice.
In terms of that, how
This
many
entire cross-examination is really an
I
ad
don't know.
for this company.
It is. I kind of want to. I want to go do some of their training. I want to go watch their podcast. I'm interested now. I'm invested in this guy's business.
Yeah.
So thank you for that.
I don't know.
Going into those trainings, I did find an article about
I
one
think
of
Kim
somebody was saying
Potter's
how
predict
wonderful
was
your training
wrong as
was. It was
well.
on
Correct,
Force
Logan?
Science, but you had Laura Scarry, an expert in police litigation and management. Her expertise reflected insights that can only come from representing over 100 police officers in moments immediately following their critical incidents. Why do you need a labor attorney representing something that's Force Science that's supposed to be teaching about psychological behavior, psychological factors, behavior, and memory?
Yeah, so Laura Scarry is an operational attorney as well. So when an officer is involved in a critical incident, she's the attorney who actually shows up to the scene. And so she's very familiar with the human performance issues in the immediate aftermath of shootings, and also the legal issues. So what she's trying to do when we're teaching investigators and those who evaluate cases, what they can expect. A lot of people have never done this before, what they can expect in the immediate aftermath of a shooting, particularly in relation to the officers that were involved. Laura Scarry is an incredible resource for that purpose.
You're not a big fan of progressive police reform, are you?
I mean, there's some aspects of progressive police reform that I think are fantastic, and there are some that I think are either beyond human performance capability, or they just reflect a very different priority than traditional law and order interests.
Okay. This is one of the articles you wrote on that, isn't it? 2021, progressive police reform.
Yes.
Okay. In this article that you wrote, you really don't like body cameras, do you?
I don't think
Body
any
cameras are
cop likes
amazing
body
tools.
cameras.
You wrote, if you believe that police are racist, abusive, and corrupt, then it makes sense to mandate body cameras and enact policies that prevent pretext car stops, restrict consent searches, and limit investigatory stops. That doesn't sound like it's an amazing tool to me if you think the way you're mandating them is because their police are racist, abusive, and corrupt.
Will you read that again? I don't know
Sure.
what you're talking about, the body cam. You can just read it. That's fine.
I want to make sure. Go ahead. You read it. Top paragraph highlighted.
It's like truckers that don't want the dash cams in the cars.
I think you need to read the entire article. In fact, I would encourage you to.
I read the entire article, but that's your line. You wrote, it makes it, if you believe that police are racist, abusive, and corrupt, then it makes sense to mandate body cameras. That's your sentence you wrote. Correct?
I wrote that.
Okay. You also wrote that if you believe that police profession is illegitimate and untrustworthy, then it makes sense to construct and empower layers of civilian oversight. So you don't like civilian oversight of police, do you?
No, I do like, well, civilian
I don't
oversight.
think this
Yeah, I
was
do
said.
like civilian oversight, political oversight of the police. Would you like me to read the entire article? It'd be great.
No, not really. Because
Not.
you just need that one sentence. I mean, I don't know how you can get a better context. No.
Have me read it.
But
It'll
now
be
the
better
jury definitely
Wait,
want
you're
to
okay
read
with
that
civilian
entire
oversight,
article.
please?
Yes, I think civilian oversight. One of the things we learned about civilian
In
oversight.
redirect,
there was
do you
there
think
was
they will
yes,
read
there was
the
a belief
entire
that
article?
When you bring civilians in to evaluate police, the first thing you have to do is get them to see the world through the lens of the police officer. So that required training. It required them to actually go through what police officers go through the simulators and to understand the law. And then we put them in a sim to understand the reality of it so they could feel it. then they could actually engage in honest accountability. Civilian oversight, people got nervous because they thought civilians were going to be harder on the police. What it ended up happening is civilian oversight actually was a lot more liberal with police performance than their actual police officers were. And so any concerns about civilian oversight really came down to, are the civilians who are conducting oversight doing it through the lens of a reasonable officer, or are they coming in to conduct civilian oversight with and actually intentionally not allowing the officer's view? Civilian oversight in the progressive reform area, there were some examples of it where they would say, if you want to belong to the civilian oversight board, you cannot have been a former police officer, you cannot be related to a police officer, and you could not have gone through specialized training for police officers. And so when we started to see that, we would push back on that kind of reform effort, because it was actually having people, civilians, evaluate police without actually doing it through the lens of the officer, which is what the law required. So these are debates that are happening across the country. So
I believe that's a proper debate. I don't agree with this guy, though.
Well, you made sure.
I believe civilians that are overseeing the police should not be former police, right? Because then you get a lot of insider stuff. It's like a lot of agencies, like the FDA is just populated with people from the Food and Drug Administration, and then you get self-policing. It's not really oversight, right? So, but does it discredit his position? I don't think so.
That when you have a son that's a police officer, correct?
Well, to me,
It goes right to his statement about, I got a quote regarding civilian police.
His son.
Well, it pertains to his son. You select your comment. You selected a department where politics hadn't infected the agency or civilian leaders for him. Isn't that true?
I think she sustained the objection.
Well, I read the quote. She said
That was awesome. The witness is like, I'm not going to answer that. She sustained the objection. Although he didn't realize he was asking a different question.
Isn't that true?
I think she sustained the objection.
Well, I read the quote. She said, that's a different question. The quote is, you made sure that politics hadn't infected the agency or civilian leaders where your son became a police officer, right?
Objection, Your Honor. This is the same topic, so.
What?
It's the same topic, but
But it's not- how is his son relevant?
So you asked a question, she objected, I sustained the objection, you asked another question.
Rephrase it.
And then he said, oh, you sustained, but he didn't mention son the second time. Then the third question, now here's the son again, so.
Well, this goes
You
to,
can ask the second question again, and then if you can bootstrap that to make it relevant, but
Well,
whether or not his son is a police officer, I think is beyond.
correct. But the thing is where he goes, why he chose where his son went. And that's what his quote was, that politics, civilian review boards where civilians hadn't been infected.
Right, so the second way that you phrased the question was fine.
Okay. So you made sure that politics hadn't infected the agency or civilian leaders, correct?
Yes.
You have a problem with prosecutors who try and hold police officers accountable, don't you?
No.
No. Do you remember talking in once again, Betsy Brainerd Smith? I think that's how you say her name, nationalpolice.org, NPA?
Yes.
Do you remember telling her you have a problem with prosecutors who charge police officers where you lost the gatekeepers? Progressive reform activists trying to hold officers accountable are doing it unjustly if they don't know what they're doing, or corruptly if they do. That was your quote. You remember that?
That's absolutely true. Yes.
So so I'm a progressive reform activist prosecutor.
You asked me if you, I don't
Yeah.
know you, sir.
It's your mission right now to be here, right? You're the tip of the spear. I've said it
Mission.
before, haven't you?
When I talk about tips, I'm talking about a consulting division, because what we do is we're going around and we're training a lot of investigators and evaluators on the types of issues to look for, the human performance issues that impact perception and cognition. And then what we do in the consulting division is we actually take all of that to real world cases. So when I talk about the tip of the spear, I'm talking about if our arguments aren't persuasive in court and they're not persuasive in agencies, then we have to do a feedback and go back to the trainers and say, look, these arguments aren't working. These things are not, we're not being persuasive in these areas.
Okay. Do you remember Eric Hine Academy? A guy from, I think he's from Holland. You talked on a podcast with him.
Yes.
Okay. Do you recall saying, my personal mission right now is to ensure those officers who are having juries, legislatures, their own chiefs, administrators, and prosecutors indict them in a court of public opinion in criminal cases without any knowledge of human performance. I want to be there with them. My job is to be there in that courtroom. That's what you said.
Right. So what we're saying was, like we talked about earlier, like honest accountability versus corrupt or unjust accountability. The two standards are, if a prosecutor is trying to hold an officer accountable to a standard that is vague, uncertain, and the officer's never heard about, then that would be a standard by which an officer could not predict the lawfulness of their own performance. That would be unjust or corrupt accountability. If a prosecutor is attempting to hold an officer accountable to a standard that is beyond human performance capability that no human could do, then that is also another example of what I said is if they do it unknowingly just because they don't have an understanding of human performance, then that's unjust. If they do it intentionally, then that's corrupt. My job and our job is to ensure that the triers of fact understand the reality of human performance in critical instances so that we have honest accountability, not unjust or corrupt accountability. So we are 100% committed to honest accountability of police officers, and that is part of our mission statement.
Going to your actual report, one of the things you talk about, you kind of very similar to Professor Stoughton. You talk about when you look at the use of force event, there's got to be intent, means, ability, and opportunity. That's how you phrase it.
Correct.
Right? And intent means somebody wants to do it, right?
They're willing to. Yeah.
Willing to. Means they have a weapon system. Right. As I think you said it. Ability means physically upright, mobile. And opportunity is a position where the weapon system could actually reach you. That's how you phrased it in one of your podcasts. You don't like, in terms of determining that, you don't like the American Law Institute,
he has a
new
podcast.
standards where they talk about necessary. Officers struggle to understand necessary, proportional, and minimum force standards, right?
Right.
Okay. But one of the things you did in this case is you said Patrick had intent because he had disproportionate resistance, right? That was your statement, right? Disproportionate resistance. Patrick engaged in disproportionate resistance, ergo, the officer could assume he was going to use the taser.
Yeah. So when an officer's evaluating a suspect's conduct, remember it's based on training, education, experience, and reasonable inferences. I think the statement that he's making is when the officer sees somebody who is resisting at a level that is disproportionate to the suspected offense, that it is reasonable for that officer to believe that there's much more going on, and they have to prepare themselves for the fact that there might be
I think that's common sense, right?
Yeah. So is it
you didn't need a
reasonable
study
for
for
when someone
that.
is fighting you? You think you pull them over for a turn signal violation, and they're fighting you at this level of aggressiveness, for example, that it's reasonable for an officer to infer there's something more serious going on that this guy's aware of that they've yet to figure out.
But that's what I'm saying. But for the officer, you don't like proportional use of force. So you can use it against the victim, Patrick, because he's disproportionately resisting. But an officer, proportional level of force, they don't know how to use that. That's crazy. How do you expect them to do that? That's your position, right?
No.
Well, as you said,
I don't understand that.
Officers struggle to understand necessary, proportional, and minimum force standards.
Right. So these are not standards that are typically involved in constitutional policing.
Question: can the prosecutor keep hammering on the podcast if the jury didn't see the podcast? Yes, because this guy is being offered as an expert, and he was qualified as an expert. Anything that is used to form the basis of his opinion can be challenged, and it doesn't necessarily have to be admitted into evidence to do it. A good example is like a learned treatise. So if there's a doctor on the stand and there's a medical book that says, in fact, this procedure that you're describing went out of date in the 1860s. We don't use bloodletting anymore. He can be challenged with that learned treatise without it actually being introduced in the evidence. Similar thing here. He can challenge him on things he said in his own podcast because he's an expert and because presumably these things that he said or he's talking about has informed his opinion on this case. So that's how that works.
These are not standards that officers are trained against when we talk about. In fact, Stoughton and his academic colleagues have written articles to try to incorporate these standards because the current standard doesn't. So they're advocating that necessity and proportionality and minimum force necessary. So if you imagine for a second, again, it is beyond human performance capabilities for a human to look at another human and know what is the minimum force necessary to arrest this person and overcome resistance that they've never felt. And yet we'll see that language sort of incorporated because it sounds great, right? But we wouldn't ask a firefighter to put out a fire with minimum water necessary. We don't ask wrestlers to pin somebody with minimum force or football players to tackle with minimum force because a human cannot possibly know what that is.
Well, so I do believe they ask football players to tackle with minimal force.
Vague standards that have not evolved through case law. Officers don't know what they mean. And so we have these conversations. These are the academic debates we spend an awful lot of time. So, welcome to the debate. These are things that are not well settled. These are things that academics want to have to wrestle with, and they're wrestling with them in courts as we speak.
And so you don't like them. That was my point. You don't like minimum standards. You don't like proportional use of force, right? You don't like putting that standard on an officer.
I don't like any vague standard that doesn't allow an officer to predict the lawfulness of their own behavior. So if you tell an officer you can only use minimum force, and they would call me when these new standards for, again, a lot of the progressive reform efforts were coming after, they were coming fast. And so agencies would call and say, hey, we got this new policy. Officers have to use minimum force or use only force that's proportional.
So they won't. So the question is, do the prosecutors have to disclose the articles to the defense before impeaching the witness with them? So generally, the rules of disclosures of evidence, like the Brady rules and things like that, the parties have to disclose exhibits and evidence ahead of time, unless it's used solely for the purposes of impeachment. Then if they're going to use it for impeachment, they have to give it to the other side at that moment, but not in advance. So presumably the podcast is a little weird because it's not a physical thing, a document, but they do have to show it to the other side for the purposes of impeachment at that moment, though, but not anytime before that.
What does that mean? And we would say that has not been decided yet. We don't know. And so until those things are fleshed out, either defined in terms, this is what we discussed in Bakersfield with the ACLU, they were using terms that police officers had never heard before. And so, and I got them to agree that we cannot have standards that don't allow officers to predict the lawfulness of their own behavior. They're like, of course not. That's a due process violation. It's absence of notice sort of thing. If the officer doesn't know what's illegal, we can't hold them accountable for violating it. And so my objection was when we start adding all these new
terms. Does that apply
to
to citizens as well?
Terms I've seen. Officers don't know.
Is ignorance an excuse to private citizens? I think not.
Know what to do with them. So that's what I was pushing back against. But in my academic capacity, those are just discussions we're having until those things get fleshed out more, either in courts or through legislation.
But it's okay for an officer to determine disproportionate resistance from a person.
Absolutely, yes.
One of the other things you said, the basis for why this was justified is that you even talked about it to the jury, MMA, right? You said real world combat sports and law enforcement experience confirms that suspects can turn explosively from the prone position. In wrestling and mixed martial arts, MMA, fighters routinely explode from a prone position to reverse control over their opponent.
Yes.
So you're comparing Patrick to an MMA fighter. You can react like that.
I've seen that in jiu-jitsu, not just MMA, with brand new kids who've never been trained before or adults who've never been trained. It's a human I'm comparing to another human.
So even though MMA fighters go through 3 hours of training every day, 2 hours a day,
assumes facts,
6 hours
not
a
evidence.
day, that's a very different thing than Patrick, who's an African immigrant with his pants falling down and barefoot out on a grassy front yard, right?
Yeah, completely unrelated, yes.
One of the other things you talked about was his superhuman resistance. That was your words in the report, right? Yes, I think I used the word superhuman as what it was perceived to feel like, because of all of the efforts that the officer was putting into it was unable to overcome the resistance. So what that's often is like, it feels like it's superhuman resistance. Superhuman, it's not a legal term of art. It's a lot of resistance. So you're taking that inferences from his statement, that suspect's superhuman resistance. Yeah, it's a characterization of the level of resistance an officer in that position might have characterized it as. So what Patrick did was beyond human, having a higher nature, greater powers than humans have. That's what you saw in the video? If you're going to read that word literally, I suppose that's what a dictionary would say. That was not how I intended it. You're a lawyer, right? I am. Lawyers use words, right? We do. And so words have meaning, right? They do. So you put in a report that a guy who stood up and walked across a yard was superhuman, right? Well, the characterization of that force would feel like that. He didn't have superhuman speed, though, did he? Because clearly he got caught. He did not have superhuman speed. But just superhuman strength to be able to stand
Invisibility,
up. Right?
Perhaps?
The literal definition of superhuman, I suppose if I go back and rewrite it based on this cross, I would use a different word just to avoid this. But the concept's the same, which is when you're trying everything you can to overcome the resistance, and this guy's standing up, you're an adult male, and another adult is standing up with you repeatedly, and there's nothing you can do to stop it. I use the concept of it would feel like almost like superhuman strength in that moment. Like, this is not consistent with my understanding of past practices on trying to control a human. But yes, the word superhuman was probably not the best choice of words. Your Honor, I got maybe a few more. I don't know if we're going to stop now. I think I could wrap up here relatively within the next 5. Well, I can stop there. I don't get into a minute, so I can wait till Monday.
I don't think the prosecutor is doing especially well here. Especially not with a simple answer. This witness gets the entire courtroom to laugh at the prosecutor.
I think he wants to break here so that he can go home and recoup for the weekend and then come back on Monday. By the way, we are watching the tail end of day 5. So now we're going to get into the live testimony from this morning and closing arguments. All right. So that was the end of day 5. I am not any closer to finding guilt than I was at the end of the direct examination.
Nope.
So let me find the spot where we begin here. I didn't realize it would continue to play. Let's see here. Wait, what is this? Okay. So we're going to continue cross-examination here. This is from this morning. Closed captioning is not available here. I am going to speed it up. If it's too fast, let me know. Oh, I think they're waiting for the jury to come in.
Like I said, not a whole lot of additional questions, but I do want to get a few things. One of the things you talked about, though, in your direct exam is that you're kind of a network of experts you rely on, because I think one of the questions was Mr. Stout or Professor Stout and Mr. Bloomfield were not part of your network. Is that a fair statement?
Yes, sir.
Now, in terms of, obviously you get hired as an expert, you're retained to provide testimony, correct?
Yes, sir.
When you give a defendant access to the expert, do you get compensated for that as well?
No,
Is it
sir.
on top of, you get paid for this. Do you get paid for
No.
giving them access to these other experts?
No, we don't charge a referral fee in our process. No.
But Mr. Bartel would be part of your network, if you will.
Yes, we would reach out to Mr. Bartel if his CV supported the need. Yes.
And Mr. Blake would be part of your network as well.
I don't know that we've ever used Mr. Blake, but I would certainly consider his CV if we needed it. Yes.
What about Dr. Kroll? Is Dr. Kroll part of your network?
Dr. Kroll is, yes.
Okay. So in terms of, did you, in this case, did you facilitate? Did you reach out to them to say, hey, I got a case for you, kind of?
No.
Okay. But that you provided that information to the defense so they could reach out for this case.
I don't know. I think they had already found them in this case. I don't know that I actually referred them in this particular case.
But that's the idea, right? The law is supposed to be something that everyone can understand, and so therefore ignorant is not an excuse, or ignorance, right?
Yeah.
But I have a hard time with this when they have these, broad sweeping, assertions, right? And I'm going to say assertions because these aren't laws. These are just police practices. Just because you violate a practice doesn't mean it's a violation of law. And that's the fundamental issue I'm having with this state's case is they're like, well, he violated police procedure, therefore he's guilty. But that's not, that's not how the law works.
No, that should not be the standard at all.
Yeah. Now it is a reasonable, so the person, the self-defense in Michigan is like many other states where it requires an objective and a subjective analysis. Was the actual defendant subjectively in fear of great bodily harm and or death, and would a reasonable person in similar circumstances? So they say, well, you need to have a reasonably similar person, so a police officer with similar training. That's the objective standard. So, but that still doesn't go, just because he broke procedure and say a reasonable officer wouldn't break procedure is still not the legal issue. The legal issue is a officer with similar training in that situation, would they reasonably be in fear of great bodily harm or death? So none of this matters to me from a legal analysis, and I'm not sure why any of it's allowed in. That was actually the basis for the defense's motion for a mistrial at the end of day one, was that very reason, because it's not relevant. It just confuses everybody.
We talked a little bit about the international chiefs of police and the foot pursuit policy.
Yes, sir.
And then, like you said, it's not mandatory, it's adopted, correct?
Right. Just to be clear, the foot pursuit considerations paper, I couldn't find an IACP foot pursuit model policy. What I saw was the second resource, which is a considerations paper, but I think that's what you referred to.
Well, in that considerations paper, they talk about foot pursuits are inherently dangerous, right?
They are, yes.
Do you disagree with that?
No.
One of the things they said, decision to pursue a fleeing suspect should not be regarded as required or even prudent in all circumstances. Do you disagree with that?
I do not disagree with that.
It all depends on the seriousness of the offense, the totality of the circumstances. That's what they talk about, correct?
Yes.
Hey, Vodka Blood, welcome.
In terms of, people flee the police for all kinds of reasons, right?
They do.
Some people flee because they curfew violation to a serious felony offense, right?
Yes, sir.
And one of the things, I think it was Eric Hine, the podcast you talked about. Do you recall talking about sometimes innocent people are the most difficult people to deal with because they know you're innocent. You're still trying to figure that out, right?
Yes.
So when you're looking at a chase, it's based on the totality of the circumstances. You would never recommend a single officer chasing 4 armed suspects down Arc Alley, would you?
Well, if you're talking about the two different types of chases, I think we may have discussed chase to pursue or chase to contain or chase to capture. It wouldn't be unusual to chase 4 people. It might be unusual to try to capture them all simultaneously.
So chase to contain is part of the thing. You chase and you're keeping an eye on subjects and calling for backup and trying to get, establish a perimeter, right?
Yes.
All right. We talked about, I don't know if you were here, but just the CLIA, just for the record, Commission on Accreditation for Law Enforcement Agencies. You're familiar with that?
I am, yes, sir.
And that's kind of we've heard it, that's the gold standard, if you will.
That's their marketing slogan. I don't know that they're considered the gold standard universally. There's many organizations that do what they do, but I think their marketing slogan is they're the gold standard. Yes.
Okay. And it's all, I think we heard that only like 5% of law enforcement agencies, ballpark, are CALIA accredited.
Yeah, I don't know the percentage.
But Grand Rapids is CALIA accredited.
They are, yes.
And you're not faulting. I mean, it's a good thing to have accreditation, right?
Yes.
And one of the things that CALIA does is they take a look at comprehensive and uniform written directives that clearly define authority, performance, and responsibilities. That's one of the criteria CALIA uses when they look at a department, right?
Okay, I'm sorry, I did miss that. We say that again.
They look at, is there a comprehensive and uniform written directives that clearly define authority, performance, and responsibilities? That's one of the criteria.
I don't know the CALIAs in front of me. I would take your word for it if that's one of their written criteria. Yes.
And part of how they do that, though, is they bring in people from departments from all across the country, right? Just to look at the policies of a specific department.
I don't know that that's their policy. No.
You don't know how it's done. You don't know the process of CALIA.
I know the process of CALIA. The evaluation model. Sometimes just a couple of people that have been hired by CALIA, and they would be regional representatives. So I don't know how many or where they get. Typically, I know of one regional representative that will work with the agency. You've listed I think your broader question is, do they pull in people from across the country? I don't know that they do that.
Okay. But part of the policy that you cite, though, the policy that it's taken a look at is Grand Rapids policy bases the reasonable of any use of force is ordinarily judged on the totality of the circumstances, i.e. based on all of the circumstances. That's clearly Grand Rapids policy.
Correct. Yes.
Thank you. Nothing further, Your Honor.
Thank you.
Morning, Mr. Clean.
Good morning.
On Friday, you were asked some questions about who Force Science is consulted with in this case. And you previously testified you consulted with defendants, students, community members, and prosecutors. Has the prosecutor's office in this case ever consulted with Force Science?
Yes.
And are you aware of whether Michigan State
that's
Police
interesting.
investigators that are involved in this case has ever attended a Force Science course?
Yes.
So both the state police trooper that was the lead investigator and the prosecutor's office consulted with this guy's company on prior cases.
On prior. Oh,
this prosecutor is building relationships with all of his local cops and his experts.
Yeah,
that'd be good.
Do you recall when approximately we retained Force Science?
I believe ultimately it was September of 2022.
Have you ever met with or talked with Officer Schurr about this case?
No.
Did you have any part in preparing Officer Schurr for his statement?
No.
Thank you.
That was good. Short,
We
sweet,
never consulted
and done.
with this case.
Not on this case. No.
There's been years in the past.
Yes.
Not this case.
I think it was maybe just two in the past 2017 timeframe.
Thank you.
Hey, Wendy. Do we have jury questions?
Hey,
I'm curious to see what these are.
Hey, Mr. Clean, where can we buy that course?
I mean, come on. He looks like Mr. Clean. His name is even Clean. Wow. So, if you haven't seen this before, the jury is allowed to ask questions in Michigan, and the judge and the attorneys review the questions to make sure they're appropriate. Then the judge will haphazardly read them and reinterpret them in her own way, which isn't supposed to happen, but that's what happens in this case. Unless they're inappropriate or not really questions for the jury or for the witness. One of the jurors asked if he could use the bathroom during this little Q&A section. So we'll see what questions there are. It's always a good insight, which made me a little nervous about guilt or innocence. I feel like there's some jurors that might be leaning towards guilt, at least manslaughter, based on these questions, but we'll see.
Yeah, at least one juror.
I feel like this is trial prep. Like my firm should pay me to do this.
Yep.
Because I get an insight into potentially reading juries from their questions. I use this almost like when you're in law school, they tell you to go sit in on trials. Go sit in on cases, look at other attorneys doing stuff, find things that you like, find things that you don't like. You can pick up on some tips and tricks. And so I'm going to call this trial prep. That's what I'm doing here. So they decided to ask questions. Oh, there we go.
Does this mean that that Lego you're building is deductible?
It was already deductible since it's part of my advertisement on my Lego stream. But yes, Yes, the Lego. This is law entertainment here. This is all marketing for the law firm, don't you know? See, I have my logo prominent in the video. I thought she started asking questions before the sound went back on.
To clarify, your opinion is based from you looking at everything: videos, audio, reports, autopsy, testimonial, and then human factors, or the other way around?
That was a good question, actually. So is your opinion based on all the evidence that you reviewed and then the human factor, or the other way around? That was the question. So, Wendy, I have new merch up. I have a merch store now. Back up again. But that was a good question. I like that question. I'm going to back it up just to make sure I got it right. But I like that question. If I got it right.
Audio, reports, autopsy, testimonial, and then human factors, or the other way around?
So we would start with the first. So we would look at the facts of the case, the evidence in the case that was available at the time. So that would be the videos, that would be the audio. And then when we're taking that and we're trying to evaluate the officer's decision-making and performance, that's when we consider the human performance aspects.
Next, when you got drive stun in your head, how long approximately did it take to recuperate?
I don't feel like that's an appropriate question, but okay. Judge allowed it.
Well, once I realized that I was okay, it was probably less than 30 seconds. I think the initial shock of it probably took more time than the recovery did.
And then next, if the subject didn't have full control of the taser during the time deadly force was used, would you still consider it a reasonable action? Or is this what makes it reasonable?
That's interesting. So the jury is concerned, or at least this particular juror is concerned about how much control that Lyoya had over the taser at the time, which is exactly what my thought was at the time. Like, and that's why I've always been on the fence. I'm like, I don't see that there being a way for Lyoya to actually be able to tase the officer in that position right when the shot is taken. So in my mind, it's not self-defense. Now, based on the testimony and some of the video analytics, you can see where Lyoya is actually manipulating the taser. He's switching it from one hand to the other. And you can't really see on the right side, but what exactly he's doing. But it looks like he's deliberately still holding on to it and shifting it around and gripping it with his right hand. So, but that's interesting. That's what the jury's thinking.
Yeah, it's again, the standard I'm using is, could a person in the officer's position, knowing what they knew, reasonably believe? And so we don't look at actual threat, we look at apparent threat based on the available information to the officer. So if we later learned that if the officer reasonably believed he had full control, and later learned that he didn't because we could watch a video or do a still shot, we analyze the case based on the apparent threat from the perception of the officer at the time, not what we would later learn. I'll just stop there. I think that answered it.
I'm not sure I know what you mean by your question. Would there be greater aggravating factors in manslaughter as opposed to unaliving? I mean, second degree unaliving. Taking into the totality of the circumstances. I'm not sure what you're getting at, but maybe this will help. So manslaughter is like you intend to do the act, or no, I'm sorry, you don't intend to do the act, but you do it, and you don't intend to cause a death, but you do. Second degree is you intend to do the act, but you don't necessarily intend to cause the death. And then third degree, or a first degree, is you intend to do the act and you intend to cause the death. That's the basic difference between the three. So obviously there's a lot of nuance there, and that's not exactly how it's stated. But so maybe that helps you. I don't think that there would be any aggravating factors that would be greater in manslaughter. It just basically would be, it was an accident, you know.
Any follow-up from that, Ms. Hamilton?
No, Your Honor.
No, Your Honor.
All right. This witness is done.
Jury, may this witness be excused? Mr. Hamilton?
Yes, Your Honor.
No objection?
And no question, Your Honor.
Thank you very much, sir. You are excused.
Thank you, ma'am.
And then you may call your next witness.
Defense rests, Your Honor.
Defense rests.
And Mr. Becker, are you prepared to put on any rebuttal evidence?
We do have one brief rebuttal witness, Your Honor.
Oh, we do get a rebuttal witness.
I'll detective to agree with.
Is it one of their witness experts?
And since you were sworn previously, I'm not going to have you re-sworn, but I am going to remind you that you are still under oath.
Yes, Your Honor.
Thank you.
Who is this guy?
Secondly, going through, I want to get into one of the things you do is you obviously you try and get a statement from the defendant in any cases like this, correct?
Yes, I do.
I'll let the record reflect that I'm showing opposing counsel exhibits 37 and 38 for these exhibits.
I don't remember his name.
Detective, I'm going to show you what has been marked as exhibit 37 for identification purposes. Could you tell the jury what that is?
I'm sorry to interrupt, but 37's already been admitted.
I'm sorry, I thought we had 36.
37 was already admitted.
Okay, I got to go 38, 38, and 39.
And 37 was training records.
I agree.
Outline.
So that's why I had Detroit Police Commissioner on and Grand Rapids Commissioner on, because they were already talking about the changing in procedures. One, at least that the Detroit Police Commissioner was talking about, is that having 2 officers per car as a mandatory with very few exceptions. That's one of the things that the civilian oversight, such as the Detroit Police Commission, is pushing through right now. So if you were a former officer, is sitting in that position, would you be pushing for that? So I like the civilian oversight. But yeah, I agree. It's definitely going to change some standards.
What it was.
Okay, so let's try exhibit 38. Can you tell the jury?
More hiring practice.
Yep, this is a typed written statement. It's 3 pages long. It's signed by Chris Schurr on April 15, 2022.
And how did you get this statement?
I requested through his defense. I believe Mr. Dodge facilitated getting this to my office.
Okay, and what you did is after you get this, you turn it over to our office as make it part of the case file, correct?
Yep, this becomes a part of my report.
And I'm going to show you exhibit 39. Could you tell the jury what this is?
Yep. After that original statement, I, along with my colleagues, had a couple of follow-up questions. Numbered those out. I believe it was 13 specific follow-up questions. Purely voluntary, but I reached back out to Mr. Dodge and I asked if Officer Schurr would be willing to answer these follow-up questions, which he did. So this is, again, typed answers to those questions, signed by Chris Schurr on May 13 of 2022. It's 3 pages.
And once again, you made those part of the file as well.
Yes, I did.
I move the admission appeals exhibits 38 and 39.
No Your Honor. 38 and 39 are now admitted.
And just for the, just because you didn't, there was not during the interview, this was just typed
Correct.
at some point in time away from you.
Yes.
There's one follow thing. Why is the state police investigating this? Happened in the city of Grand Rapids. Why is the state police on this?
Yeah, we have a formal agreement with the Grand Rapids Police Department. Again, I work for the Michigan State Police. And before my time and above my rank, formal agreement was made with the PD that if they had an officer-involved shooting, that our department goes and investigates those. So really, I was there on invitation based on a formal agreement that was in place ahead of time.
Thank you. Nothing further.
I don't know what he did. I don't know what this witness did.
Morning, sir.
I just want to ask you some questions about the statement. That was just.
So all they wanted was
circumstances under which
statements in?
under which you obtained them. You touched briefly on this. Now this was obviously a case that.
You know, I don't
drew a lot of
remember.
attention,
Dark Lotus.
from the public. Is that fair?
Yes, it is.
And you were among several detectives that were working on this case.
Yes.
And you
There we go.
recognize that
State detective.
Christopher Schurr was under no obligation to give a statement, right?
No, this is purely voluntary.
Okay. And if you in a normal case, went out to talk to somebody and said, we would like to talk to you. If they said, we don't want to talk to you, then you can't force them to talk to you, right?
No, and that carries no weight with me, the response.
Okay, but you were doing this investigation. There's a lot going on. And you wanted to hear from him, and you reached out to his attorneys, right?
Yes, I did.
Okay. And by that point, he had Mr. Dodge as counsel, right?
Yes.
And I think you said that the first statement was in April 15th of 2022.
Yes.
And that's something that was signed by the defendant.
Yes.
But came through his attorneys.
Yes, it was.
Okay. That's not an interview you had with him shortly after the incident or anything like that.
No, there's no interview.
And in a case like this where there's a shooting, you actually give the officer some time to reflect anyway, right? Before you would try to interview them, right?
That's standard. That's typical.
Okay. So you don't pounce on them like right after the shooting and start asking them questions.
By the way, I hate this, that cops give other cops time to think about it before requesting a statement. If it was a civilian, they'd be standing over the still warm body. Tell me your story. Tell me everything you did this day and hand over your phone and everything, right? I hate that double standard.
If they wanted to, I would not say no, but I've not had that experience with an officer before.
And then you got the statement, you asked some follow-up questions, and you actually wrote questions on the second statement that's dated May 13th. Is that fair?
Yes.
And again, it came through counsel, and to the best of their ability, you believe that you got some answers to the questions you had.
Yes.
Okay. But that's not everything that you might have wanted to ask Officer Schurr, right?
No, sometimes when I'm interviewing somebody, those interviews can go on for hours and hours and hours. This was, if I had to ask some pointed questions, it was a short list.
Okay. And so I think it's 13 questions. That's pales in comparison to the number of questions that he could be asked on, say, like cross-examination, right?
Yes.
Okay, thank you.
No, Your Honor.
On the jury. Step down again.
You may, Your Honor.
So unimportant, the jury didn't care.
No additional rebuttal, Your Honor.
That's it. Case is done. We get closing arguments now.
So I would like to take a break because looks like the evidence is complete, but we need to go over some things outside of your presence.
Last chance to vote in the poll if you want to vote in the poll, because this is free closing.
Go into the back and we'll take a 15-minute break right now. And meanwhile, even though all the evidence is finished, you're not deliberating yet. So I'm going to ask you to still keep your notes and not discuss the case amongst yourselves or with anyone else. And also
The arguments need to be made. The arguments.
and media and social media. And then we'll see you back in about 15 minutes.
Yeah, if you haven't voted yet.
Wendy,
Vote
it's
now.
your time to vote now. All right. The case is done. I'm going to close my poll, and we have 54% not guilty, 31% second degree, 15% manslaughter. See, that's why this is so interesting.
And my poll says undecided 45%, not guilty 18%, and guilty 36%.
Wow.
So from Friday to now, it switched back to guilty.
You're glitching out a touch, unless it's me. Oh, they're talking about the jury instructions. All right, so Nick, you want to answer Wendy's question first?
Please tell us why you changed your minds. I missed a lot. Well, I'm still, if it only were for that half second, without any testimony, I would be guilty. Problem is that the prosecution fucked it up through extremely bad cross-examination of the defense experts.
I totally agree, and that's why I kind of changed my vote too. Because I'm more of the Well, I don't know now. Like, I was certain, like, I watched the video and I'm like, I don't know, that looks pretty bad to me. And then with the testimony that was elicited specifically on the defense's case in chief when they analyzed the video, and then a little bit of what the officer had to say, because that's his perspective, Officer Schurr. I got to the point where I'm like, it could be self-defense. He could have been in fear. And now if the state's unable to, rebut that, I'm going to have to go with not guilty. That's where I'm at. Because I can't get all the way to beyond a reasonable doubt. Like, yeah, it looks really bad. And yes, if I was in his position, I would hope that I would have done something different, like stood up. But then again, I'm not seeing everything. And then when you see that the taser, like part of the video analysis, you could see that the suspect is actually still in 100% possession of the taser and then switching it from his left hand to his right hand. That's scary, because if it was me, if I was in his position, I'd be like just dropping it and trying to get up, right? Why am I hanging on to the taser? That looks bad. So that's why I'm in the undecided, and therefore I must vote not guilty. So that's where I'm at. Oh, here we go. Okay, so we're going to hear some talking heads for a minute, but I think they're cutting into the closing argument.
Let's take a listen.
I hope we are getting calloused. And callousing is the fact that how many times do we watch this video?
Is this closing?
After dying, over and over again. It wasn't TV. It's not movies. This is a real man, a human being, who was shot in the back of the head back in April 2022. We watched it over and over. He's got a family. He's got loved ones.
Thanks for welcoming to the right side.
It's just something we see because we somewhat get immune to somebody dying over and over and over again. And we try and take a rational kind of look at it. And I think the other thing, when you look at it, it's a serious crime, but it's got one of the more simple elements, if you will. Because it boils down to just a few elements. There's a lot of the crimes you're not aware of, but elements are what we have to prove beyond a reasonable doubt. And so when it starts off, we talked about over and over again, this is the first element. Patrick died because of a gunshot wound to the head, but the defendant did to him. And so that the other part is, yes, this is also about him, about what he did. Because Patrick is no saint. I'm not going to sit here and argue Patrick was a saint. He was drunk driving.
He was going to college the next day, though.
Resisting. He was driving without a driver's license. None of those are executable offenses. There are ways to deal with it. It's just because he committed a felony. He could commit 20 felonies. He could have had other felonies. It doesn't mean he deserved to die or he has to die. That's for juries. That's for other things down the road. The other thing is, I'm not going to sit here and say he's a horrible person.
Yeah,
he's got a great family. We heard about
the guy who threw a bottle deserve to die?
That's wonderful. That's great.
I was going with Mads about that, and Mads said in Discord, I think he's like, well, I believe that was the right call. And I do too.
Yeah.
For that bottle case. But why wasn't that made in this case?
Yeah. Because a bottle thrown at you or in your general direction, or the threat of a taser.
Right?
And you have that bouncer. He was not alone. I mean, you had multiple people.
Mm-hmm. Yeah.
Was he really in fear of great? Was he in fear of great bodily harm? Yeah. Bottles hurt. They can hurt. They will hurt if they hit you.
Yeah, he was trying to break in back. He was trying to get back into the bar, and I get that. And it's not just the bottle that was thrown, but still, to say that a taser is not deadly, that's why it came up in conversation. To say that a taser is not a potentially deadly weapon, but a beer bottle thrown from quite a distance is. That was the comparison I was trying to make.
Because you don't compare, okay, one's good, one's bad, we'll just throw it up there. You have to base the case based on the facts. You'll hear from the judge that sympathy or prejudice shouldn't play a role in your decision. So you've got to base your decision on the facts that were here, the facts that were what the witnesses said, the videos, all the policies and procedures. That's what you have to base it on. Not, well, he's a hometown boy and want to do good, and we've got this bad guy who's drunk driving. It's not that simple. It is simple in terms of the elements, though. Clearly, the defendant killed Patrick back in April, and he had an intent to do so. Because part of the instruction you hear, there's maybe 3 different states of mind, but I'm going to stop at the first one. There was an intent to kill, and the intent to kill. Please don't get wrapped up. Nobody's saying that when we left that morning that he intended to kill somebody. When he fired the shot, he intended to kill. That is clear when you put a bullet in somebody's back of somebody's head. So in terms of the elements they have to prove, the first 2 are proven, no question in your mind. Those are the 2. Those are the easy ones. So what does it come down to? Why are we here?
I don't think this prosecutor rehearsed this.
Number 3. Number 3, was the killing justified or excused or reduced to a lesser crime? That is your decision. That is why you're here. And justified, I talked a little bit of cross-the-line clean. Words matter. And words matter in terms of it matter. We're going to hear a lot of instructions, and sometimes jurors get wrapped up in terms of instructions that, this is the law, and while we're in a courtroom, and somehow things change because you're in a courtroom. You lose your collective common sense, you'll hear that instruction from the judge. You have your own common sense, you have your experiences. The words that you use out there have the same meaning here. Justified, done for a good and a legitimate reason. Excused, removing something you had to do. You're excused from school. You have a duty to go to school. You're excused from school. You're removed. So what is the duty here? You have a duty not to kill somebody unless it's a really darn good reason. That's the duty you have here. That's the duty any of us have here. There's no difference between a police officer or a civilian. You can't take a life without a darn good reason. So when you start looking at that,
you mean to say a darn good reason?
There's also a little bit of confusion in terms of the law. What is the law? Okay, what is the law? And the law impacting the policy, because you've heard that there's the policy of GRPD. You have to follow the law. Okay, the judge will tell you your job is to follow the law policy, and what the policy is, in fact, may impact how you interpret the law. And what
I think it's really
just winging it. On the left,
where's the red line? Where's the story? Where's the story? Where's the red line?
I think he is winging it, right?
Yeah.
He's not telling a story. He's walking through the elements, and maybe we'll get to a story now because he's got past the first 2 that everyone's agreement on, that that the defendant killed this guy. So maybe we'll get to a story now.
Yeah,
honestly and reasonably. Once again, words have meanings. Honestly and reasonably. It can be 2 different things. You kind of think of the same thing, but you can have an honest belief, but it's not reasonable, right? There's a lot of people that believe that have an honest belief. We never landed on the moon. It was a big hoax. Nobody landed on the moon. We made it up.
Is he talking about the moon landing?
California.
Bring up flat earthers. Birds aren't real. Come on, let's get them all out there.
Is it reasonable?
The Magna Carta.
What is reasonable? And what is reasonable is also defined. And there's 2, you'll see the same thing. You have the policy of GRPD is not vastly different from what the law is. You kind of take a look at the reasonable person under same or similar circumstances, looking at the totality of the circumstances, looking at everything that happened. What led up to that decision to fire that shot? You have to take in everything from the start to the finish.
No matter the outcome, I don't think he will win the next election.
You've heard that testified to on a number of different occasions.
Yeah, I don't know.
So you have to, what is the reasonableness when you break it down? And once again, dealing with the facts of what was presented here today, or here this week, that the time you're paying attention to. Well, maybe putting it another way, it was reasonable to shoot Patrick because he had the taser, he was outnumbered, exhausted. That's really the justification. That's the excuse. Okay, and that's an important thing because it's not that he pointed the taser. Nobody said that. The defendant took a stand. Can't say that in a statement. Never said he pointed the taser at me. He simply had the taser.
I feel like that's enough.
The best we could get at was, maybe he was starting to turn and he thought he may be pointing at him.
Is it your opinion, prosecutor, that he should have waited until he had a taser actively pointed at him?
So that's my thought, right? Okay, so yes, possession of the taser itself might not be enough, but possession of the taser in the way with the opportunity and potential intent to use it, that's where we, that's the issue here.
Now, say this was a knife, and you see you're at the guy's back. He has rough control over a knife, and then all of a sudden he grabs it in his right hand. Is it now a threat?
No, not yet, Law Kong. I haven't brought up Christmas and apple pie yet.
Yeah, there's no mailboxes in this case.
No.
It may be pointed out. No evidence, no evidence, never said he threatened it, said he was going to use it, that I would kill you, said anything like that. He simply had the taser as one of the justifications of why I had to shoot. And the other one is he was exhausted and alone, outnumbered. So, kind of taking that second one, let's take a look at that second one going from that perspective. Okay, why? Why were we in that situation? Well, it goes back to the chase. There's no dispute that, the defendant had the absolute right to try and place him under arrest. Okay? He was driving without a license. And that's the thing you have to look at it. At the time, he knew driving without a license and had a bad plate. Those are the only two reasons. Okay? There's nothing else. Nothing else that the defendant knew at that point in time. So you have to take it at that point
That's
in time.
what made the Lyola's action so scary.
That came up later. So at the time,
what if this guy had just unalived 2 other cops and he was armed to the teeth in that car? Right? Let's assume that, just for the sake of this argument. Let's assume that's the actual situation that Lyoya was in when Officer Schurr approached him. That could be extremely dangerous for Officer Schurr. Officer Schurr doesn't know that. He knows nothing, and that's why it's scary.
Time, he makes the decision to chase, and we're going to play the videos. We've seen it ad nauseum, and that's a great thing. Now you can go back in the jury room and play those. You can look at whatever you want. You have the ability to replay it, take different looks at it, pick whatever thing you want. Please take a look at it. Go over it. You paid attention, but now you can really talk
if it's
about
been tried by the jury of his peers, are there any cops in the jury?
Yeah, they weren't going to allow cops on the jury.
It's a tackle on that. Well, within a minute, that's testimony. He's tired. He's exhausted and outnumbered. That's one of the first things he says in the statement. He's exhausted and outnumbered within a minute. Now, mind you, how 1 minute, this is one of the best fit officers in the Grand Rapids Police Department. He's exhausted and tired within a minute. Well, apparently they should never chase anybody then, if that's the circumstances. And we're not saying, though, that police can never chase anybody. It's based on the totality of the facts and circumstances. And in this case, look at what's going on here. We talked about the use of force 9-1.5.
Sir, your expert said that an officer should never chase down a suspect if the suspect runs past the front bumper of his vehicle. That's what your expert said. So don't sit here and say, well, we're not telling anybody not to chase him down.
Size and stature, multiple subjects, relative strength, access to weapons, all those point against that. Because from the get-go, he knew he gets higher, he knew he was bigger. We all, we heard from the testimony of Captain Steiger, we saw how he moved, got jumped off, kind of moved when he spun, got lifted off the ground. He was we didn't know he had access to weapons. That's a scary thing, because how many times over and over again did we hear about Grand Rapids Police talking about traffic stops, unknown traffic stops? You have to anticipate there are guns in the car. You have to anticipate that the people with the car in the car may have a weapon. But we have a person flying off chasing, not knowing about guns, not knowing about there's another person, knowing that the person's bigger and stronger, and yet doing that. But then using it to turn around and say, well, I'm outnumbered and I'm exhausted because I chased somebody. That's troubling. That's troubling to use that as a justification from the get-go. There's plenty of policy, and that's what we talk over and over again, Exhibit 36. That's the one policy we see, a set out policy. If you're looking at policy, how does that impact the law? That policy says, hey, if somebody's armed and dangerous, you're perfectly fine in following behind, having a plan, not tackling. It's bad tactics to tackle.
Seriously, is it just me? Is it just me, or does this sound like he's just rambling? I
zoned out. Sorry.
No, I don't know if it's just me or not.
Brought that up, that the defense then brings up, well, they're trying to chase. And they have to go over chases, but the chase that they talk about in Exhibit 31, they bring it up You're responding to assist in a foot pursuit. Solo officer gave his last location and no further updates. You're your first time to scene to assist. And what does that talk about? The officer's in trouble. The solo officer's in trouble, and so you got to assist this officer in, he got himself bit off more than he could chew, which is essentially what happened here.
The prosecutor's suffering from Trumpitis.
Running off.
Just listen. I mean, the officer's suffering from Trumpitis. Like I love Trump, but the way he talks, he's like, like it was for like he doesn't finish a thought. Listen to this again. I'm just backed it up 10 seconds. He doesn't finish a thought.
And he got himself bit off more than he could chew, which is essentially what happened here. So yeah, they train and you can chase. Let's basically you don't go running off. Fine, please.
What did he just say?
I have no idea.
What
I have literally no idea what is going on about.
I have no idea what he just said.
He says, yeah, I'm not going to advocate somebody go running off and chasing people down a dark alley. You're outnumbered. There's no business. When you don't know the situation, call for backup and do that. But now they try and use that as justification of why this all happened. The next part, the next major part is the taser. You grab the taser. Okay? And these are screenshots. These are some frozen screenshots from the frame-by-frame video that you have an opportunity to take a look at. When you look at the frame-by-frame, this right here, the one on the left is, you can see the taser, that's the moment the taser comes out. This is a little bit further behind because it's just about to be deployed, because you see the two dots on here from Nick Bloomfield in terms of that's where the shots are going to go at that point in time. So when the grabbing of it during this period of time, what's going on? Why would you make it? And Nick Bloomfield's the one that says, well, yeah, you can use a taser, but you got a whole big issue with weapons retention right here. And you see why. You see why is because that's exactly what happened. He grabbed onto it. He grabbed onto it right then because he's face to face. But once again, you get back up. It's not like you're just looking at the silos. What did we talk about before? What did we talk about the criteria, if you will? Patrick's still stronger. Patrick's still don't know if he's got weapons. You're still outnumbered at this point in time. You're actually sticking it. You're trying to stick a gun where this guy who you just tackled, had two hands on, were on top of, gets up and walks away, and now you're trying to hold on to him with one hand. And then deploying the taser at the same time, and that's gonna be a good idea. And so this is, we have experts, this is Mr. Bloomfield saying, that's not a good idea. And you kind of see why that happened, but it also once again talks about policy going against. What does taser say? This is from the PowerPoint. We go over the PowerPoint.
This is gibberish. It really is. He switches from telling a story to then first party narrative as if he was Officer Schurr, and then quotes the expert. It's gibberish. It doesn't flow together. It doesn't make sense.
No.
And Wendy wants to convict.
Yeah. How much does this prosecutor make a year?
I don't know. I would say at least 190. Kent County's pretty rich, so 200 probably. Yeah, he needs to join Toastmasters. Yeah, right.
Taser says about it is that employ other force options or disengage. Okay, so Patrick did a bunch of bad things, but that
yeah, go shopping on Nick's merch store if you guys are zoned out.
That led to this firing a shot, and he's using those as justifications. Well, this all happened. Ergo, I need to use deadly force. And
don't say ergo, sir.
Professor Stoughton and Nick Bloomfield, they're the ones. They don't disagree with everything that happened here. Yeah, you get pulled over. Yeah, he had a right to arrest. When these certain critical areas, there are critical mistakes that occurred here that a reasonable officer, not using 2020, a reasonable officer wouldn't make those same decisions. You don't try and chase him as bigger instructor. You don't try and bring a taser out holding on to with one hand in a position where he can grab the weapon, especially when taser says, hey, disengage. And the ideal footage that somebody has to use for a taser is 4 feet, even with the closed cartridges. Because we went over that. A closed cartridge, yeah, this taser 7 has the ability to use closed cartridge, but closed is 4 feet, not an arm's length, which led to all this. So looking at the totality of the circumstances, you justify, well, I used a taser, I chased somebody, so I had to use, I shouldn't have, but I had to kill them. That's essentially what they're arguing. So one of the things you also have to look at is the imminent threat analysis. And this is kind of interesting because, one of the things they talk you hear in terms of all the witnesses, the experts on both sides, Von Clean and Professor Stoutman on both sides, they kind of use the same analysis, right? They talked about this. The imminent threat means and intent, opportunity. Okay, I think there's a motive. I think Von Clean had motive. There's a similar thing. So if you think about that, when does that prove an imminent threat? When does it happen? Well, once again, you just don't. Use the defendant's statement because okay, you can testify to this, but take a look at the statements. Those are exhibits 39, 38, 39. The last two things I just admitted. Because when you go back and I cross-examined on him, in terms of what did he think was going on, what was going on at the time, after trying to get away. Because these are his statements. He began to walk away. He proceeded to turn away. He ran away from the stop. He would not comply with commands and continue. I think the last two are the key. Continue to move his arms and legs in an attempt to get away. From the get-go, all this time before the taser grab, he's got the idea, yeah, Patrick's trying to get away. I
feel like if you weren't in the firm guilty camp already, you'd be moving away because
Now imagine the rebuttal closing after the defense.
Oh yeah.
It's only going to get worse. And I remember you saying this, that you rarely win on closing arguments, but you can lose.
Yes. Yeah. I mean, yeah. By the time you're giving closing arguments, you're only there to reinforce something that the jury already acknowledges. That's what I just said. Unless you're already in the clearly guilty camp, you're starting to move over towards the not guilty camp with this closing.
Dude, that's what he says in his statement back in April of 2022. Okay, Patrick's not threatening me. Patrick's not taking a swing at me. Patrick's trying to get away. That's the whole basis. Even when it comes to the taser. And that's the thing, that's the key moment, okay? That's where something more is happening here. He puts his hand on the taser. What is the defendant's impression? The defendant's impression is he moved it so he'd not be struck. And that also compares when you think about, you start comparing, you compare the witnesses. What do the other witnesses say? What does Wayne Butler, the neighbor? Wayne says from the get-go, yeah, Patrick's trying to get away. Wayne says, yeah, he's trying not to get tased. That's the whole thing. It's not an expert. That's just a normal civilian. A neighbor sitting there watching everything. He's not trying to get tased.
That was the best witness in this case, though. I love that.
A lot of what Professor Stoutman and Nick talk about. There's an intent to flee. There's no intent to harm. There's no assault going on here. He's trying to get away. You don't get to shoot somebody because they're trying to get away. That's not a justification. That's not an excuse. That's what the law is. And that's what the impression of everybody here, including the defendant, because that's the statement. So when you start looking at it, has the ability to have an intent to do great bodily harm. That's the imminent threat analysis. When does that start? Was it here? Because once again, you get to look at the pictures now, because right here, clearly, that one on the far side, he's moving away from him. That's obvious to everybody. So why now, just because he's got his hand on the taser, is he going to use it against him? He's never tried to swing at him. And you go back to these. Look at
now he's going into this is Patrick's intent. How is the cop supposed to know? Oh, I was just moving away. Yeah, had he survived, he could have testified to it.
Yeah,
but
exactly.
This is pure speculation.
Also, I don't think he's talking about the right timeline because when the shot is taken, Patrick's not moving anywhere. He's staying there. He's fumbling with stuff under his arms or under his body, right? Yeah. When the shot's taken. I mean, that's fairly clear. I never said that It never appeared to me that he was trying to get away at that moment the shot was fired. And that's the only moment that really counts, right? At the end of the day.
Yeah, it's that final half second. What did Mr. Schurr believe?
Yep.
Opportunity, right? He's arm's length away, both hands are open. Take a swing, punch, do something. It's grab the taser, get away from him. So once again, how does a reasonable officer in this situation think I'm going to die? When a guy who's done nothing more than keep trying to get away from you, to keep trying to walk away from this. How does a reasonable officer get that out of this? And then you go to, and these are exhibits from the body cam, or excuse me, the cell phone video. You hear about, Professor Stone and Nick talk about, their opinion, based on generally accepted police practices, was that a reasonable officer in this situation would not make the decision to fire. And what did they say? One of the reasons is, well, he was never in a good tactical. Patrick was never in a good tactical situation. And look at this. This is a good tactical situation when you're on the ground. He's on his back. Take a look at it. He's flat on his back with the taser at his side. Okay? He's not. And once again, what does Wayne say? Wayne kind of says the same thing. Wayne's not, once again, not an expert saying he's winning. The defendant's winning, I think he said. There's nothing coming from Patrick. Okay? Right here, this is the one thing they point to. Right here, just before the shot was fired, his legs get lifted off. His legs get lifted off the ground, but within a little over 10 seconds, he's back on the ground. So you break it up. So until the taser's grabbed.
1, 2, 3, 4, 5. That was only half of the 10 seconds in which you have no control over the situation because your legs are off the ground and everything. You just said, well, within 10 seconds, his legs are back on the ground. That's a long time.
That's a lot of airtime.
Yeah.
We have the defendant saying, yep, he's trying to get away. What happened in the next minute, 10 seconds approximately, that would make a reasonable officer think he's going to die? What did Patrick do?
Well, yeah, Schurr's testimony in his own behalf was not excellent.
It wasn't. I'll give him that. It was not.
But, I mean, the prosecutor could have done a better job in cross-examination as well.
Look at us coming along.
Dun, 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 dun. Gotta stop before we get copyright struck.
We're certified by CLIA. They give us, that's generally accepted police practices. You have other agencies come in and take a look at things in generally police practices, and that's what Professor Stone and Nick base their decision on, base their opinion on. When you take a look,
yeah, two armed individuals, right, Lao Kong?
Why would a reasonable officer think he's going to die when he's simply trying to get away, never in a tactical situation, by their opinion, and as well as the civilian witness who saw it at the same time? So it also comes into this part. I'm trying to play it. Hopefully it works.
I mean, he is playing the video and everything.
Because that was one of the bases. That was the basis of Nick. Nick Bloomfield said, well,
I'm sorry. If I'm trying to focus on this guy that's running away, I don't want to hear from the peanut gallery. I don't want to hear from the audience, the other passenger, because then that's just going to make me more concerned.
Yeah.
The taser couldn't, there was no neuromuscular incapacitation. That was not possible because right there, because that's the second. And Brian Child says, yep, there's a second deployment. So it's been deployed twice. There was no probes that were going to fire out at that point in time. So he couldn't been incapacitated. Well, they call him, David Blake saying, what the heck's going on? We need to, he doesn't hear anything. There's tunnel vision. There's, he's going to skip things and miss things. And his explanation at this point in time is, well, he could have, been out of breath. Out of breath, I mean, listen to it and watch. Drop the tape, and then he moves it away as well. There's plenty of knowledge that he knew exactly what happened, but you also take a look at everything else.
The judge is not at all paying attention.
What else? All these other things that he heard through this entire incident. Take a look once again at his statement. He heard everything. He heard the neighbor coming out of the house at the beginning. That's when the fight's still on. He heard that other He didn't hear him, but that's still hearing. Other units were on the way. He could not hear sirens later on. After the taser struggle, he knew that there were no sirens coming, that other cars were approaching. So he heard everything, and suddenly there's just one thing he misses, and that's on top of all the other perceptions he was making at that point in time. He saw, I mean, this is, he testified, here, he saw the red on the taser on what was happening. So when you look at all that, he was aware of everything, so suddenly this one thing he missed, that he wasn't aware, he wasn't aware that that taser had been deployed twice, so there's no chance of neuromuscular incapacitation. You have to ask yourself that. How is that possible? One thing, you just missed one thing out of everything you perceived. I mean, he perceived at the moment he fired the shot, in his statement, he says, yep, I checked the background, there's nothing there. So it's not like he says, I don't remember what happened. He says, yep, I was checking everything, I saw everything, I heard everything through this entire incident. So there's knowledge there that the taser was not able to be fired that would cause NMI. And the fact that it suddenly maybe the NMI, that it could have caused pain, we heard over and over again. How many times did we hear from the various defense witnesses? Were you tased? Yeah, all those, it was painful. It was painful as heck. It was, it was burning, it was everything. Pain is not a reason to use deadly force. You can't use deadly force because you're going to be in pain. There's no instruction. You can use deadly force when you think you're going to be killed or you're going to be seriously injured. Pain is not part of that. Just because it's going to cause you a lot of pain. Burning the pain of 1,000 burning suns doesn't justify it. But they try to work that in now. And they try and add that in. And quite frankly, look at his statement. That was never the concern back when he wrote his statement back in April. The statement was he was afraid that he was going to get tased, there's going to be neuromuscular incapacitation, and then Patrick was going to grab his gun. It wasn't the taser that was causing the issue, it was the fact that he may get shot. So NMI said,
yeah, shocked, so the perp would get the gun. That is scared for great bodily harm.
But that was the
what the
which also going into policy, we're trying to determine what policies should have an impact. You heard over and over again, what was the policy in 2020? Exhaust all alternatives before firing. And I thought that's kind of interesting in terms of, what they talk about. They keep on saying, well, in terms of, if you make the decision to use deadly force, does that mean you have to go back down? That's not nobody's arguing that. Like I said, during one of the witnesses, if somebody comes out with a gun and points it at you, you don't have to try and use pressure points, right? Nobody's saying that. But when you're in terms of a struggle over that lasts a couple, 2-3 minutes, yeah, you got to try something else. And what do we have here? We have arm strike, one arm strike, a bunch of knee strikes, taser gun. What does JRPD teach on this? Why are we going over it? 4 hours, they're recertified. That's where you take a look at the exhibits, all the training records. They are taught for every year, going over all the pressure points, all the different stuns, all the different strikes, all the different things that are used to try and get control over a person who's not willing to be arrested. You don't need to use all this stuff. You don't need to do stuns and takedowns and pressure points. You don't need to grab somebody by the side of the jaw if they're compliant, right? You only do that is when they're not compliant. None of them were used. Zero. Not one.
What?
So what is the purpose of this policy that says exhaust reasonable alternatives when nothing happens? They don't use it. It's ignored. Doesn't even try. Arm straight, kick, taser gun. That's all we have here. And then that's part of the policy we talk about, require a warning shot. Now they say, well, it doesn't make a whole lot of sense that maybe stop is enough. Maybe stop is, we don't say stop or shoot, but there's some sort of warning. So we kept on saying, you drop the taser, that's enough. That seems that once again applies in the face of the policy that says is a warning shot must be given, or a warning shot, warning must be given before firing the shot after you exhaust all reasonable alternatives. None were exhausted. There was no early warning. It was just a shot in the back of the head from a guy who was trying nothing more than to get away. There was no threat there. He wanted to get away. Whatever reason, he wanted to get away. We don't know why. We don't know why he made that decision. He was drunk. That could have played a role. But that didn't mean he should die on that day. So when you look at it, a lot of what we are basing on, it's two experts. Our two experts, Professor Stone and Nick Bloomfield, and they base it on generally accepted police practices. What would reasonable officers do under this situation? And when you look at it, they take a look at the whole thing. As you look at it, there's I think Professor Stone said, there was an imminent threat. A reasonable officer would think there's an imminent threat of somebody trying to get away, but that's very different than an imminent threat of somebody trying to kill or hurt or injure somebody. Those are two different things. And once again, that's also backed up when the one civilian who really saw everything here, Wayne Butler, he kind of said the same thing. There was no evidence that Patrick was trying to hurt or do anything. He was trying to get away. The primary act was resistance and an attempt to hit harm, and he didn't do harm. I think that's an important thing. There's a fight to the death, and that's why I showed those pictures. There's a fight to the death, and the most injured, you got maybe some redness on his wrist. You're not fight to the death, and they keep on talking about a fight. How's a fight? Once again, a fight is defined as throwing punches, doing something else. This was a wrestling match. The most I can say, all the witnesses said this was active aggression. Okay? He was pulling away. He was wrestling. The only thing they can say is, well, potentially, maybe, he could be, the defendant thought maybe he was going to turn and fire the taser. There was never a tactical advantage. That's what they said. Never a tactical advantage. So why would you think that you need to do it at the moment and fire that shot? Because what had happened over and over again. You saw Patrick try to get it once, but then it shut it down. Patrick got it again. What did he do? He walked away. So this time when Patrick's trying to get up again, he gets shoved down. Watch the video. Take a look at that video. He gets shoved down again. He never got up, fully walked around the second time after they went to the ground on the taser. They were wrestling. Patrick went to get up. He was shoved on the ground, and that's when the fatal shot was fired. The defendant had tactical control. The defendant was on top of him the entire time. Why would you think you need to use deadly force under these circumstances? So what happens? If it's not reasonable, it's not lawful self-defense. That's the only thing that justifies it. That's the only way we get out of here without a verdict of guilty under these situations. There's not a reasonable officer to think that Patrick was trying to kill him based on what was here. So what does that mean? The defendant's guilty. This is a traffic stop. At the time the defendant knew what was going on. It was for a bad plate and no driver's license. What out of all this made him think he was going to die? Get his taser? That's not enough. He was tired. The guy was tired. Everything great. We don't need to beat over the head that he was tired. He was tired because he put himself in that situation. There was no reasonable officer that would think he was going to die based on the facts and circumstances here. So the verdict that you must come at the end is guilty of second-degree murder, and that's why I asked you to return the verdict of such.
Wow. All right, defense.
Morning, everyone.
All right, we got.
Thank you for your patience.
Sorry, what did I miss? How did that end?
Now I sold out. I mean, it.
Okay.
It was just word salad, incoherent, start and stop, and changing his mind mid-sentence because he realized he was almost saying the wrong thing. And
I wasn't listening, and I was on a phone call, and but that's all I need to know. I zoned out. That's all I see Derek. Oh no, it was Dark Lotus. It was like this closing is disingenuous. Yeah, so I'm like, that's all I need to know.
Yeah, and I mean, the first thing the defense attorney says, "Thank you for your patience." I mean, yeah.
Oh, all right. Let's hear what this has to what he has to say.
The prosecutor is trying to.
I want to preface this with, I haven't been able to give the defense a glowing review yet. I think both sides are pretty bad, so we'll see. I did put up a new poll after closing. Where are we on guilt? So second-degree manslaughter and not guilty is up.
Make this case something that's not. You're here because you're going to judge my client, Christopher Schurr, on the decision of whether or not to use deadly force in a situation, on his decision and his belief that he was in fear of either great bodily harm or death. You are not here to judge the GRPD policy. You are not here to judge whether it was reasonable for him to chase.
Much better so far.
You have to decide whether the prosecutor has proven beyond a reasonable doubt, whether Grand Rapids Police Department Officer Christopher Schurr had a reasonable fear of great bodily harm or death. That is the issue. And you must look at it as to at the moment of the threat. When Patrick Lyoya had the taser in his right hand,
That's what I've been trying to say.
whether or not Christopher Schurr was reasonably in fear. And the prosecutor has failed miserably. I want you to look at just the case that the prosecutor put on. And I would submit to you
It's my understanding. Well, he's definitely being charged with second-degree murder. The question is, what's he being charged with? Is there a lesser included? I am fairly certain that there's a lesser included of manslaughter, but I'm not positive on that. So but that's why I put manslaughter in the poll.
prosecutor didn't even meet his burden in their case. You heard from a couple of Patrick Lyoya's friends about what occurred the night before leading up to the events. There was a night of drinking. Mr. Lyoya wakes up.
It was the morning of drinking too.
The witnesses who were there. He's with Aime Tuyasheme and David Bakuru. And the prosecutor put on evidence of how much everybody was drinking. That was the prosecutor's case. And that they got into a car. No one is suggesting that anybody should be executed because they're drinking and driving. That's absurd. And that's nothing to do with what happened here. Yes, he was drinking and driving. Is that a bad thing? Yes, but nobody's saying they deserve to be executed, and nothing like that happened.
I like this so much better than anything else this guy said.
Later on, took his taser.
I don't like that he used
what
the
happens?
word
They get into a car,
execute.
and it has a license plate from a different car. That means that the license plate belonged to a totally different car. Mr. Lyoya and Mr. Tuyasheme and another person was dropped off so that person could take his kid to school, and then they drive around. They visit Mr. Lyoya's new apartment. They stop to reload on Budweiser, and they're driving around again. When, according to Mr. Tuyasheme, they hear a noise in the car, and they were driving around. They take a couple right turns. He stopped on Griggs Street in Grand Rapids. And then Mr. Lyoya quickly exits the car to see what's going on. According to Mr. Tuyasheme, he really wanted to hear what the noise was to try to figure out how maybe something wrong with the car. But at precisely that moment, in an incredible coincidence, that's when Officer Schurr had pulled him over. You can decide whether or not that's.
And I think the law that supports that is that you're supposed to take into consideration a reasonable officer in that similar circumstance, right? And so I think that's what gets us there.
That was the case, whether or not that's even relevant. But Officer Schurr, it's irrefutable and undisputable, he had a valid reason to pull him over. The plates didn't match the car. He's a police officer. That's his job. He's at work. It's 8 a.m. on Monday. That's his job. That's why he's pulling him over. And the prosecutor agrees it's a lawful stop. After getting out of the car, Officer Schurr gets alarmed. You can hear it in his voice. He orders him back in the car. 4 times. Get back in the car. Get back in the car.
He needs to keep this
Why
short,
is he doing
though.
that? Because he's trained that if somebody jumps out of their car, that could be a problem. So he orders him back in the car, and Mr. Lyoya refuses. Officer Schurr doesn't know why. He doesn't know why he won't go back in the car, but he just approaches him. But he doesn't know anything about a broken down car, because did you hear Mr. Lyoya say anything about, hey, my car's not working? There's a funny noise. No. So we're talking about the knowledge and in the situation of the officer here. So what does he know? He just knows somebody jumped out of the car. Instead of answering lawful questions, which the officer is allowed to do, Mr. Lyoya decides to start questioning the officer. What I do wrong? And then Officer Schurr is asking questions at the same time. Neither are getting answers. Officer Schurr, he says, you have a license. What for? Do you have a license? For what? Do you have a license? What do I do? Do you have a driver's license? Do you speak English? Because now he's wondering, maybe he doesn't understand what I'm saying. Mr. Lyoya answers that question, yes. Can I see your license? What did I do wrong? And then Officer Schurr just starts answering his questions. He tells him, well, the plate doesn't belong in the car. That's why I pulled you over. He's hoping to get an answer from Mr. Lyoya. Do you have a license or no? Do you have a driver's license? Yes. Where is it? It's in the car. Get it for me. What did I do wrong? The plate does not belong in the car. He answers his question again. Police officers are supposed to ask questions at a traffic stop. They're supposed to get your ID. That's what a traffic stop is. And that's what he's doing here. And if you want to see how Officer Schurr responds when somebody actually complies in the smallest amount of way, watch this interaction. Look at his body language. Listen to the tone of his voice. When Patrick Lyoya says it's in the car, get it for me.
Well, I can't say he said it that calmly, but okay.
Right. Yeah, I think he's underselling it a little.
Yeah.
So what follows after this is a series of decisions by both of them. Patrick Lyoya is making decisions. Officer Schurr is responding to those decisions and making decisions of his own based on his training as a police officer. He's doing his job. Patrick Lyoya decides to walk away from police. Why? We don't know. Officer Schurr is trained, though, that failure to comply, ask yourself why. There's not a lot of good reasons for doing what he did. So he's alarmed again. So he went from, get it for me, please, to, oh, here we go. He's walking away. So I have to go back up. He decides he's walked away. I'm going to have to arrest him. Why? Because as a police officer, he's committed a crime. And it's not his job to decide who gets set free and who gets arrested. His job is to arrest. He is on the street to detect crimes and arrest people for them. And it's committed right in his presence. He doesn't think, well, I'm not really going to arrest this guy today. That's not his job.
This is kind of cool. Look at the guns turn.
So then you saw that Mr. Lyoya,
hey,
after Officer Schurr lawfully went to arrest him, resisted arrest. And we can argue about all day.
I say it's a little slow and tedious, but it definitely has a storyline and is much better than the state's
like this.
Rambling.
I agree. He didn't face up to him that many times, just a couple of times. He shoves him, and then he decides to run. Why is he running? Officer Schurr doesn't know. He doesn't even know his name at this point. Officer Schurr does his job. He calls it in immediately.
Do we have any unsupported irrational speculation as to why he was running?
Right, somebody's running, and he catches him. He's arresting him. Feet from the car. Why? Because he's a police officer, and that's his job. He's doing exactly what we expect him to do. He doesn't get to decide, well, I'm just going to let this person go.
Who's the coffer?
That's an option under his training, but he made the choice to pursue him. And Professor Stoughton agreed that the initial pursuit was fine. He's just mad that he disagrees with the fact that he didn't peel off once he got near on the other side of the car. And you saw that Patrick Lyoya continued to resist arrest. He lifts him off the ground. Why? Yeah, he's getting away.
Gigi and I are on the same wavelength.
But Officer Schurr is not trained to figure out what the motive was for the fact that he's resisting arrest. He's just resisting arrest. He doesn't have time to ask him questions. Why? Please just stop. He's not answering anything that he's saying. He's telling him to stop. So Officer Schurr decides to use greater force because he's a police officer and that's how he's trained to handle it. Knee strikes, commands, open hand blows. You heard that they were open hand. So he's not trying to hurt him permanently. He's using his open hand. That's how he's trained. And obviously, they're not effective. He didn't take out a stick and hit him on the head or anything like that. He's trying to arrest him. That's why he's using intermediate force. He's trying to get him to command, to comply within the bounds of his training. Then you see Patrick Lyoya, he decides to get up and walk across the lawn with the officer in tow. Officer Schurr doesn't know why, but it's not his idea to go that way. Who's in control of this situation? He gets up. He walks him across the yard. Intermediate force didn't work. You hear Mr. Lyoya yell, "Get the keys." Well, sure looks like he's developing a plan to get out of there. So Officer Schurr,
that was bad.
Get in his car and go
right?
away.
So why else would he be asking his passenger to get the keys? Unless he's saying, "Hey, get in the driver's seat, get the keys started up, and I'll be with you in a moment."
Hey, so I'll just let him go. No. It's his job to arrest people that are committing crimes. He can't just decide, well, I have to let him go now because he's saying he just wants to get his keys and get out of here. The suspect doesn't get to decide when to get arrested. So he pulls out his taser. That's the next step.
But jury, he didn't want to be arrested.
It's perfect. Everybody agrees it's perfectly appropriate to use intermediate force here. Fires the taser. As everybody agrees, Mr. Lyoya grabs it and moves it to the side. That was Mr. Lyoya's decision. That wasn't the officer's. He didn't say grab the taser because he put it in front of him. This is not an affirmative act of aggression, reaching out. He grabbed it and he never let go. And he tries to get it from Chris. And look what the officer's decision here was. Did he pull out his gun? No. Did he go to deadly force here? No. He decides to physically try to get it back. He's got the taser in his possession. He won't let it go. And Patrick Lyoya decides he's not giving it back.
Is this sped up?
The officer's yelling at him to drop the taser. Let go of the taser.
Oh, this is normal speed.
And then the fight is on. They both want the taser. That's what they're fighting over. And Officer Schurr has a right to it, and Patrick Lyoya does not. And Officer Schurr did not use deadly force to get back the taser. That is not why we're here. They go to the ground, and the film goes in and out because Mr. Tuyashime I'm sorry, Your Honor, is there something wrong with the camera?
The screen went out for a moment. It's back on now.
So you see this part of what's going on. They're both still trying to get it back. And you notice that there's a part where it starts in Mr. Lyoya's left hand. And then it's in his right hand. And 11 seconds go by. And you can't really see what happens. So we don't really know how Mr. Lyoya got it in his right hand, but we know it was in his right hand. And then you see Mr. Lyoya roll over onto his stomach. Just like previously by Mr. Butler's house. He started on his stomach, pulls his knees in, and gets up. And that's exactly what's going on here. The taser is now in his right hand. Officer Schurr's trying to get the taser back still, and he can't. It's been switched. He's got exclusive control of it. He's on his back, yes. But why is he on his back? Because he's trying to get the taser back. And then you see Officer Schurr still trying to get the taser back. He's over the top trying to get this thing back. And you can see on the exhibit right there. These slides, half a second apart. Half a second. This is how quick this is happening. It's a literal split second. Patrick Lyoya has got it, holding it in his right hand. It appears from the video, it's consistent with the officer's testimony that he's holding it like a gun. It's clear in the video that it appears that Officer Schurr is being lifted up. Is he jumping up? No, he's being lifted up by Mr. Lyoya. And the angle is turning, consistent with the officer's testimony. And here, this is no longer about arrest. This is the decision you have to judge. Whether in the moment of the threat, he was afraid of that taser, capacitation, or great bodily harm. Whether it was reasonable for him to make the decision he never wanted to make that morning. Christopher Schurr was at work, and he was faced with the toughest decision of his life in half a second. That's what you're judging. Whether it was reasonable in that split second for him to think that an officer could be in fear of the taser. Not whether, what did Patrick Lyoya intend to do with it? He's got holding it like a gun, and he's getting up. He has no idea why Patrick Lyoya is fighting this hard. And he doesn't have time to figure it out. 3 years later, when you hear about his family and his friends, yes, maybe you can draw some conclusions about what he was actually thinking.
I can't. I still have no idea.
But he doesn't have the luxury. He's got half a second to make up his mind. And at this point, Mr. Lyoya has given him absolutely no reason whatsoever for him to believe he's not going to use it to get away. It doesn't matter why he's got the held like a trigger. I mean, if he's just trying to get away, he's still going to disable the officer to get away. So here we are in a criminal trial. And so now you're asked to judge not what the best practice was, but whether or not in the moment of the threat, whether the prosecutor, with his burden.
Screen froze. So the screen freeze, I paused it, but that's just now. Let's see. Oh, it seems to work fine on my end.
Prove to you beyond reasonable doubt, all reasonable
It's
doubt,
very choppy on my end.
that he wasn't in fear. And to help
Have you lowered
decide this issue,
the resolution?
the prosecutor brought
Yeah,
in
it's
some
already
experts.
lowered. It's 386 or 360.
Weird.
That's fine on my end. I've got no chop.
You heard from
StreamYard has been doing
Mr.
really
Childs,
stupid things
Officer
the
Stoughton,
past
Mr.
few
Bluefield.
weeks.
If it's choppy, it is not on my end at all, which is weird because normally I would notice it. I'm going through the monitor here. Oh yeah, wow. It is very choppy. That's not on my end at all. Everything is working fine here. It's got to be a StreamYard thing. That's stupid.
Should I test bring up the
Yeah, if you want to try. I don't know if you're going to be able to find the right spot, but I'll put it in private chat. That's the stream that I'm using. So right now we're an hour 49 behind the stream. But that's everything. That's talking heads plus jury instructions. So we don't have much left of this case.
Bill, because he is trying
That's
to prove
true.
to you beyond a reasonable doubt
Man, it
that
says
it was unreasonable for Christopher Schurr to be in fear. Beyond a reasonable doubt. And you heard from Mr. Childs. He works at Axon.
I'm trying from my end.
At this point, Mr. Lyoya has given him absolutely no reason whatsoever for him to believe he's not going to use it to get
now
away.
the audio and the video don't match, but it looks smooth.
It looks perfect on my
Why
end.
he's got held like a trigger. I mean, if it's
see how it is on
just
the
trying to get away,
live.
he's still going to disable the officer to get away.
It's smooth. It's just the audio and the video don't line up quite.
So here we are in a criminal trial. And so now you're asked to judge not what the best practice was, but whether or not in the moment of the threat, whether the prosecutor, with his burden, proved to you beyond reasonable doubt, all reasonable doubt, that he wasn't in fear. And to help you decide this issue, the prosecutor brought in some experts.
Horrible ones. Horrible experts.
You heard from Mr. Childs, Professor Stoughton, and Mr. Bluefield, because he is trying to prove to you beyond a reasonable doubt that it was unreasonable for Christopher Schurr to be in fear. Beyond a reasonable doubt. And you heard from Mr. Childs. He works at Axon. It's the company that makes the taser. So he is an expert in tasers. A taser is a weapon.
Smiley.
That's how they refer to it. And it's something to fear. The taser can cause incapacitation, even if the probes are discharged. If used improperly, a taser can blind or possibly even kill you. Probes can be reactivated once fired if they're lying on the ground. All you do is hit the button again. The wires can cause, even with wires, they can cause NMI, this incapacitation. They're insulated, but it's not a big insulation. It can get scraped off, especially if they're being dragged across the ground. The very next witness is Professor Stoughton. And followed him as Mr. Bloomfield. They wrote a joint report. And they've never heard of Brian Childs.
Wheel of Regrets needs to have a taser.
Not
I
really
agree.
sure who he is. Didn't consider his opinions about the taser. How is that possible?
Get a cattle prod from the farm.
They just flew in, gave their opinion, and flew out. It was their opinion It's reasonable to use deadly force if going to be incapacitated. So they agree. If you're going to be incapacitated and you're a police officer, you can use deadly force. It's reasonable to use deadly force if you're going to suffer great bodily harm. You don't have to lose an eye before using deadly force. That's what that means. But then here's where it differs. No objectively reasonable officer could be in fear of incapacitation from the taser, because no reasonable officer could have feared incapacitation or great bodily harm in this particular situation. In other words, the taser is not dangerous in this situation. So you heard from Brian Childs, and then you heard from Professor Stoughton and Mr. Bloomfield. And they completely disagree with the prosecutor's own expert on tasers. They say a taser is not a weapon or something to fear in this situation. The taser cannot cause incapacitation if both probes are discharged. It's unreasonable to think the probes can be reactivated after being fired. Wires cannot cause incapacitation if insulated, because it's so unlikely. The taser is about as dangerous as a thumb in your eye. And even Mr. Bloomfield, unless you're holding it like a gun. So you have the prosecution's own experts disagree with each other. You know what this picture is right here? That's reasonable doubt. You don't have to go any further. They're disagreeing with each other on the basis for why he should or should not be in fear. How can you convict someone for acting unreasonably and not being in fear when their own experts disagree? And certainly not beyond a reasonable doubt.
It's a good way to phrase it. He needs to wrap up, though.
Yeah.
Now, Mr. Stoughton and Bloomfield offer some more opinions. They admit they don't know how he's trained. And they essentially admit that there's no bearing on the ultimate issue of whether he reasonably could have used deadly force. But it has no bearing. These other opinions about the chase and the staying too close. Why are we discussing this? You're asked to determine whether or not the prosecution has proved beyond a reasonable doubt that he was in fear at the moment of the threat, and then whether it was reasonable. Why are we talking about GRPD chase policy? Because they're trying to distract you from the actual issue. And even if you consider it, it doesn't matter if he chased him improperly. It doesn't matter if he's within 4 feet or 7 feet.
I've been saying.
It doesn't matter if he used a compound sentence in his warning or is just a directive. The issue is reasonable fear. And that's why
he's not going to wrap it up quick, Mance, but he needs to.
And this training. They just don't agree with each other. You don't have to go any further. The prosecutor is also suggesting that you should just let him get away. Let him go. He hadn't punched him. That's the standard for when you get to use deadly force? Well, up to now, I know he just took my taser. He's holding it in his right hand, but he hadn't punched me yet. So therefore, no reasonable officer would think that he was going to use the taser on him. None. That's what they're saying. That's what Professor Stoughton said. It's absurd. Not one officer, no reasonable officer. That's what he's saying. No one could think they were in fear. No one could think that he might use it on him. He's got to figure out that he's got some innocent motive for taking the taser from him.
Imagine being in such a position. You have to make an argument that is so against just the video. Common sense.
If this issue, does he run away once the taser comes out, or does he turn around and grab? Does he deflect it? Or does he hold on? If it's just a reflex, I don't want to get tased, you just deflect it. Does he ever say, hey, don't tase me? Does he throw it away once he has it?
Bro.
Does he listen to anything Officer Schurr is begging him to do? Is it transferred from his left to right hand? Why would any reasonable officer think he was going to walk away politely? In the split second that Chris had to decide whether or not he poses an imminent threat, all he knows is he's fighting to retain control. He knows he's lost the taser. He knows that he's turning and rising. His fear is unreasonable? No reasonable officer could think that. You should find him not guilty after the government's case. And even though we're under no obligation to put on evidence, because his entire life is on the line, we put on substantial evidence that the prosecutor cannot show that his fear was unreasonable. We're constantly hitting these shifting arguments. You heard from the training officers, captains, Cyber, McCursey. You saw a lot of training materials. Why is this relevant? Because you're considering the knowledge of the officer, not generally accepted police practices. They may coincide from time to time, but you're looking at what, he's a street cop. He's trained. Hours and hours of training. You saw a lot about taser training. Why are you seeing this? Because this is what's in his head. But what happens when you get hit with a taser? I mean, is there any doubt that the training puts the fear of God in these guys about these tasers? They're weapons. You heard about firearms training, deadly force scenarios. One of you asked if they have implicit bias training. They do. This is a heavily trained department. And what is the point of all this training? Let me tell you about training. Officers are put in situations like this all the time. And
the judge is not at all paying attention.
You don't have time to make a reasoned decision with all the facts about everybody.
I understand her.
Training.
Yeah, I know. Yeah, she's like
now it's getting long-winded and it's repeating himself a bit.
Well, he's moved on to
the same thing. Military drills, sports. If you ever played sports,
no.
What do? You practice. So it comes almost automatic. When you don't have time to think in stressful situations,
he just seems to be a lot speedier with his words.
All right, Captain Cyber. He's a training officer, expert on GRPD policy and training. He testified that Officer Schurr trained on GRPD policies and trainings, not generally accepted police practices. Followed GRPD policy and training in the situation. Once a decision was made to use deadly force, he's not required to try other options. It's the decision to use deadly force.
It's now a race between the defense's closing arguments and me finishing this Lego build.
Mr. Becker, question. The Captain Cyber didn't do an expert report. This does not matter at all. It's irrelevant whether or not he did an expert report. He was paid exactly $0. I know you heard a lot of paid experts. Captain Cyber isn't one of them. Captain McCursey. He's an expert in GRPD training and tasers. What did he tell you? Officer Schurr was given warnings that taser is a dangerous weapon. If someone gets your weapon, assume they're going to use it against you. A taser can incapacitate you and probe or drive stun. An officer does not have to wait before being harmed or killed before resorting to deadly force. And a reasonable GRPD officer in this situation could have used deadly force. He followed his training. The captains in the GRPD believe that he was reasonable in this situation. Now, let's talk about the prosecutors experts on GRPD training. Here they are. None. So everything that involves his knowledge, you heard from the defense and nothing from the prosecution.
Here, that's what I'm building. Star Destroyer.
He didn't call a single GRPD officer.
Or the Imperial. Wait, hang on.
You know why he didn't call one?
Yeah, the Imperial Star Destroyer.
It's his burden to put on proof. Ask that question yourself. How else has the prosecution failed to meet its burden? We heard about exhaustion. Heard from Lombartel. It's reasonable for an officer in Schurr's position to lose ability to continue fighting. In a fight, you lose ability to contract muscles within 30 seconds. He was in a position of tactical disadvantage, not advantage. He fought with him for 2.5 minutes, with a man that was larger than him. He's got nothing less, and he lost control of his taser. Or from Dr. Kroll, he wins the award for the smartest witness, the biomedical scientist. Why are we calling him? Because we're trying
That's
to
the one
refute
thing.
this
There
testimony
wasn't
by
a lot of
Professor
testimony
Stoughton,
about
who
the
is not a
amount of
taser
training.
expert, that you can't be incapacitated by this thing. So if you think that Professor Stoughton actually knows more than Mr. Childs, we called another expert. Drive stun can temporarily incapacitate you through disorientation.
They're not
That's-
all
you have
bad,
the
Mads.
probes, and
We're
then you
not all
have the drive
bad.
stun. A scientist came and told you, yes, you could be temporarily incapacitated. And Professor Stoughton agrees, if you can be incapacitated and you're a fear of incapacitation, you can use deadly force. The drive stun can and has caused great bodily harm to sensitive areas. You heard this whole thing from Professor Stoughton. There's no reported deaths of police officers who lost their tasers as officers trained after they lost their tasers, where someone took their gun and killed them. And you know why? You also heard that answer from Dr. Kroll, because officers are trained to use deadly force if someone gets your taser.
Take care, totally, Pip.
That's why. He told you how many deaths there were. You heard from Dave Blake. Well, you first heard from Mr. Bloomfield that this is not the type of situation where auditory exclusion and tunnel vision or this sort of closing in, it's not stressful enough. And then he was asked, are you an expert in human factors? Well, no. So this is Dave Blake. He is. He said this is exactly the type of case where this could occur. And that Chris did not have time to give a warning. That's it. That's how much time he's got to make up his mind. That's what you're judging him on. And that decision, not whether he chased him a minute and a half before, that's how much time he's got to decide and whether that was reasonable under those circumstances.
This might be one of the cleanest cases of self-defense, or it could be one of the most unclean cases.
Dr. Blake's testimony,
So
because he went to
interesting.
an online school. But yet he wants you to credit Mr. Bloomfield's testimony, even though he didn't go to school for this. I'll let you decide who's more credible. So you heard from
I don't
these
think
force
that made an
experts.
impression
We
on
pretty much
anyone.
agree on a lot of stuff. We agree on the standard as trained. When you're in fear of great bodily harm or death, that means you can't you're not worried about a paper cut. It's got to be like stabbing, breaking a bone, or losing an eye, and of course, death. And if the prosecutor could show beyond a reasonable doubt that he wasn't in fear at that moment,
Which I don't think they can show. Not beyond a reasonable doubt.
Circumstances. And you can go through these. These are the things you're supposed to consider when reviewing whether or not the decision to use deadly force was appropriate. And we agree that a lot of these things apply. But that doesn't mean he shouldn't have tried to arrest him in the first place. This just means, under the totality of circumstances, his decision to use deadly force was reasonable. You know what's not on there? Foot chases. Because it doesn't matter. It's the decision to use deadly force that you have to consider. And he was bigger than him. There were multiple people. He was stronger than him. He got his taser. He's in a bad tactical position, or if you believe Professor Stoughton, He's in a better tactical position. The fitness level, the exhaustion, it's raining. He's getting up with the taser in his hand, and he's right next to him. All these factors point to a positive decision to use deadly force. You heard from Officer Gady.
I'm so glad the woman's not doing
He's
the
a firearms
closing.
instructor.
This guy's boring, but
Deadly
she's
force is deadly force. All the experts agree on
amateur.
this.
She's not experienced enough.
It's the decision to use deadly force that you're judging, not the location of the shot. Not one expert said, oh, you have to try to wing him or hit him in the hand or hit him in the side. That is not.
Yeah, I don't know how the rain factors in.
It's the decision. Am I in fear of imminent threat? Is there an imminent threat? Then I can use deadly force. The manner of deadly force doesn't matter. And everybody agrees to that. Where do they disagree? Well, you heard that the prosecutor's taser expert and the prosecutor's use of force experts disagree.
Nobody even
And
mentioned the
also
rain,
heard
except
that,
for I think maybe
their use of force
first
experts
witness with the camera.
didn't really rely on GRPD policies and Michigan law. Instead, they have this generally accepted police practices. And that's because Professor Stoughton and Mr. Bloomfield, they're viewing this in hindsight, and everybody agrees you shouldn't do that. It's a sort of a woulda, coulda, shoulda thing. If you go back in the jury room and say, you know, if he just had let him go, that is not the proper analysis. I wish he just, I guarantee Christopher Schurr wishes in hindsight that he had let him go. He didn't want to make this decision. That's exactly what the prosecution is doing here. Monday morning quarterback, based on all kinds of issues that don't matter. It's the moment of the threat. Look at his training, his knowledge, what he knew. And you take that into that situation and you decide that based on what was in his head, the decision to use deadly force was reasonable. In this case, they have to prove beyond a reasonable doubt that it was unreasonable. Now you heard Chris testify. He had no obligation to testify. It's a criminal case. What did he tell you? He testified about his knowledge, his training, and experience. He was exhausted, running on fumes. He was alone. He called it in right away, but there's nobody there. You can listen to the video. Do you hear any sirens? At the moment of the threat? Listen to it. Crickets. Where is everybody?
Yeah, I blame backup for all of this.
He testified he did everything he could to avoid using deadly force. He didn't.
The officer did say that he heard the call for backup, but he ignored it because he was doing a traffic stop.
What are you trying to get it back? And he's screaming at the guy, let go of the taser. It's the moment of the threat. He testified that he saw the firearm. Let's get that. In his hand. He was trying to he testified he tried to put the safety on. He couldn't do it. He's in a bad position. He does not feel like he's safe. He's pulling himself up again. And look at what Mr. Lyoya had done 3 times prior. Literally lifted him off the ground. And now this time he's got the taser. It's reasonable for an officer to think in that situation that he's going to use it on him. It would be unreasonable for him to think he wasn't.
Yeah, just let him take off with the taser. That's all. Then watch he uses that taser on someone else.
But when he's given a chance, he comes into the stand to cross-examine him as vigorously as he did Captain Cyber. He barely even asks him about the moment of the threat. What is he asking about? You didn't have to chase him, right? That's the questions they got. You stand too close to him. You're in really good shape, aren't you?
The
That's
prosecutor's just
designed to
fuming, I
mislead
bet.
you from the issue that is why you're here. He suggests that he's lying about the second pop because he said, look at the statement. Did he ask him about the hearing it? Nope. He just wants you to look at a statement that was done. As Christopher Schurr testified, I kind of wrote it like a police report after seeing the video. I mean, this video was out there right away. That wasn't his fault. And then you have the state police asking for a statement. And he's got counsel already. And he signed it, so it's attributable to him. But keep that in mind. You know, view the actual evidence, the testimony. The prosecutor has a chance to ask him all these questions. Now he asks you to answer based solely on a statement that was written with the help of lawyers a few weeks after the incident. That's not fair. He didn't have to testify, he did, and then he didn't ask him any questions. How can you assess his credibility?
It was very weak
when he wouldn't even ask the
cross-examination.
All you're left
for sure.
with was what he said originally, but it wasn't the focus of cross-examination. No, it's something he wrote kind of like a police report because he's a police officer. I mean, look at this exhibit right here. If you're wondering whether he's exhausted,
Going good,
I know he's in
Dolly.
good
We're almost
shape,
done.
but 2.5 minutes trying to wrangle a grown man
The defense's
Desperately
closing is a
trying to
little
get a taser
slow,
man.
but they're making good points.
is not the same thing as running on a treadmill. So you're going to hear about the law, and I think I have already stated over and over again what the issue is. Nowhere in here will it say, please consider whether or not Officer Schurr's complied with policy. Nowhere in it will say, hey, maybe we should change GRPD's foot policy. Please give us your thoughts on that. No. That's a distraction. Go to the next one. The relevant consideration is not what defendants should have known or done, but rather what a reasonable officer with the knowledge and the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. That's why we're here. Professor Stoughton and Mr. Bloomfield say it was no reasonable officer could have thought he was in fear. We don't.
Which I think is a silly argument.
To meet that burden. If you start discussing whether or not GRPD should have a foot pursuit policy, stop, because that's not relevant. Look at the moment of the decision. It's the decision. Please just look at this decision and whether or not there is enough there for any reasonable officer to think he might be in fear of harm.
He's so violently turning those
You're gonna hear
pages.
also that police officers do not have a duty to retreat. And this is important because private citizens do. Like if he wasn't a police officer and you saw this, then yeah, he put himself in a position he shouldn't be in. But Officer Schurr, he's not supposed to be retreating. He doesn't have a duty to retreat because he's a police
General
officer.
citizens don't have a duty to retreat either, unless you started the fight.
He put himself in danger, yes, because that's his job. You heard from one of the officers about the cowardice policy, just letting people go. You have to be sure that he wasn't in fear of great bodily harm or death before you can convict him of murder. Now, if we go to the next one, please. Honestly, or go back, I'm sorry. One more. It has to be an honest and reasonable belief. We heard from Officer Schurr. Judge him on his testimony. And judge him his testimony in comparison to what you saw and evidence.
It did have some good questions for the officer,
You
and I
heard him
don't
say
think the
that
officer
Mr.
testified the
Lyoya had
best.
exclusive control of the taser, and he did. You heard him say that he was completely exhausted after a minute, and you saw how he was 4 minutes after. And if there's any question whether he feared that taser, whether he had an honest belief, if he doesn't fear it, ask yourself, why is he trying to get it back? What is he, even after the second discharge? Does he stop for a second and slow down after that second probe goes? No, he's still going gangbusters trying to get it back. Why would you turn the safety on if it's as dangerous as a thumb? It doesn't matter what Professor Stoughton thinks about thumbs and tasers. It matters what he thinks. And look at the video. Does he slow down for a second? He's fighting as hard as he can to get that thing back. He's going over the top of him. He's putting himself at harm. Yes, because he's trying to get it back. Reasonable? This is what the prosecutor thinks is reasonable. No reasonable officer could have thought that that taser, with the probes discharged, could harm him, could incapacitate him. None, not one.
As bad as the video looks, the
He
prosecutor's
didn't even
position
talk
is
to the
so
taser
much
expert for
worse.
the prosecution, who disagrees with that completely. If no reasonable officer could have been in harm or thought he could be incapacitated, then why does everybody else, let's call it the stand, think you could, including taser experts? Especially when handled by an untrained person. You're going to hear a separate jury instruction on manslaughter. It's the first time you're hearing this.
Yep,
This is the
they're definitely
prosecution
getting
recognizing
manslaughter.
this case is weak. It's a lesser.
They added it at the end. Weak.
It's for cases where someone didn't intend to shoot the gun. Officer, he got up there and he told you, yeah, I intended to use deadly force.
You guys see that? They added it at the end of the case. They think their case
But
is
it
that
was
weak.
justified because he had the taser and I was in fear. This is not a situation where someone gets in a fight and they don't really intend to kill him, but they lose their cool in the heat of passion before they have time to cool off. They kill someone and didn't really intend it. That's a lesser included. That's not this case. And justification of self-defense is a defense to both of them. So if you find that the prosecutor hasn't met his burden to show that he was unreasonably in fear, then you must acquit to both of them.
I finished before the closings.
You absolutely cannot convict him of murder
Hey,
or manslaughter if you acquit him.
pretty
of murder.
cool.
Yeah, I got my the Lego set came today.
Oh, nice for our face-off.
Civil case.
Yeah,
Or I should say your face-off with Steph the Altar Nerd.
yeah.
A lot of you were asked.
I'm not
I
worried.
believe for anyone who's interested, Steph the Altar Nerd is going head-to-head with Nick Staroff in a Lego build-off on, I think it's going to be May 18th, but I don't know if that's
It's like
confirmed
it's one
yet.
of the most important decisions of your life, like buying a house. I agree. It's got to be, this decision is as important as those. And this is the highest burden under the law. I like to equate it to, you have a friend, family member who's on life support. and
Yeah,
you
I
have-
don't agree with the idea of it either, but they do it all the time.
That's how important this decision is. It's any reasonable doubt. Now, the wiggle room in there is if it's not reasonable. If it's an unreasonable doubt, then that's not something.
Why
you should
am I
consider. It has to be a
toast?
reasonable doubt.
Going up against Steph the
If
Altar
you have
Nerd.
any sliver
Oh, nah.
of reasonable doubt then you must acquit.
He's been training.
They have to prove beyond.
She's
Steph,
building
you
a
mean?
lot of Legos lately.
Oh yeah, she's been training up a storm.
And that his use
Oh, wrong way.
of deadly force was unreasonable.
I may or may not have taunted her, saying, "Oh,
If you're
I don't
practicing
even
well,
have
you
to
might have been
train."
justified.
Yeah, so
He could have been justified. Not sure whether he acted reasonably or not. That's an acquittal. That's the burden the prosecutor has to show before this is murder. And we just ask that you judge him on the decision and not all this noise around it. It's the split second. Any reasonable officer. This isn't murder. What an impossible decision. Make up your mind. It's not murder. It's not manslaughter. This man did not commit a crime.
yeah, it needs to be wrapped up.
No one is saying Patrick Lyoya deserved to die. That is not what this is about.
Well, he didn't commit a crime if the jury finds him
It's about
not guilty.
in the decision that we've asked Christopher Schurr to make in that moment where he's supposed to be, whether the prosecutor's shown beyond a reasonable doubt that it was unreasonable. No reasonable officer could have used deadly force in that situation.
The defense is trying to convict their
That's
client
the standard.
by
And their experts don't even
destroying the tolerance of the jury.
You must acquit him of both charges. Thank you.
All right.
Hey,
Hey,
here we
rebuttal.
go.
Oh,
Oh God! How long can? Oh,
He says brief.
yeah. Okay, yeah. It's somewhat.
The game attack prosecution's experts. That's one of the things you got to take a look at. You got to take a look at the credibility of witnesses. This is one of the instructions you get. Does a witness have any bias, prejudice, or
He forgot to talk.
decide?
He forgot to talk about the credibility of the witnesses in his first closing.
So you want to compare experts here. Let's compare for science. Force Science is not an expert entity. Force Science is an advocacy group for police officers. That's what they're there for. Bond cleaning, and that's
That
the network.
this might
That's the
not be
whole
a good
thing.
idea
You have to
because
care about
that
why
person
not police
wrecked
somebody.
you.
Now, why would you
Understand.
believe an entity that starts
He
out
got
with giving the benefit
the
of the doubt to
entire
officer? That was
courtroom to
Bond cleaning's
laugh
method one. He
at
starts
the
out,
prosecutor.
How can you be impartial? How can you be coming from a position of neutrality when you start out? You're going to give the benefit of the doubt to the police officer, which goes into
I have not sped
them
this up.
finding 98% of the time officers acted appropriately. What other profession?
He's fast and angry in normal time.
What other profession? Name one that they're correct 98% of the time. So that goes into how do you believe they're experts? Yeah, they paraded a bunch of experts out here. And it gives you just an insight of what happened. If you guys remember my question to Mr. Bartel.
If you haven't taken the poll yet, are you guilty, not guilty, or
It goes 5 minutes.
guilty of manslaughter?
It was the dumbest question
After the
ever made
closings.
in the history of cross-examinations, because the disdain from the stand just oozed out of his pores. How can you can't compare an officer to an MMA fighter? MMA fighters train for 3 hours a day, the whole years, and blah blah blah. Yet the next day, when Von Clean, his partner, his friend, who he presents with all the time, what does Von Clean do in his report? Compares
My lunchtime, Lefty.
That's what they got to do. They've got to say the opportunity. He has an opportunity because he can spring up like an MMA fighter. That gives you a window in terms of the prism. They translate what happens based on an officer. They like officers, which is perfectly fine. I'm not saying that they shouldn't have advocacy groups for officers, but you judge an officer by one standard, then you judge the victim by another one. That's the opportunity.
Yeah, but I'm going to go have margaritas made in my mouth in about an hour. So I got to fill up.
Jiu-jitsu and they do grappling. And so ergo, that Patrick has the same opportunity because he can suddenly spring up from a face down or face on his back position and maybe use the taser. That's what gives him the opportunity. Von Clean talks about, disproportionate resistance. That's their intent. That's his interpretation. That's what he said. Well, you can determine the intent. Disproportionate resistance by Patrick
Sounds about right, Lefty.
is why you can think he's going to use deadly force. Von Clean doesn't want to use that against police officers because they have no idea how can they come up with disproportion. They can't comprehend that. So
I still have no idea what this guy's talking about.
Against the experts, you want to criticize ours, take a look at theirs, and then they're comparing apples and oranges.
Take a look at theirs. They're experts. Don't worry about what ours said.
Look at them.
What a taser does, what a taser can do. And yeah, it's
It's
possible.
look a moose.
It's not reasonable to think it is going to happen. That's the reasonableness test. You can't look at every sort of possibility in the universe of what might happen and then say, oh, it's reasonable that you can do it. I mean, why does it take weak going? You listen to all the bad things that can happen on any.
This guy is not good at closings.
Because it may cause, hair loss, liver problems.
Well, he's not good at cross-examination. He's not good at calling witnesses.
There's no.
He dresses well.
There's no
I mean,
evidence
but-
where it's broken. There's no evidence that anybody was feeling MMI.
This is the elected prosecutor, folks.
Yeah.
But they gotta throw out
This is the
all
guy
these
at
things.
least one more voted for than the broomstick that ran against him.
I've got some sweet deals out of his office, but working with assistant prosecutors, not this guy.
Okay.
Investigate their own? No, they call it an independent. They call it an outside organization. How hard is it? And this is not just Jerry. This is for anybody. How do you judge someone that you train?
Wait, did he just criticize the defense for calling outsiders to testify when that's all he had?
Not biased because you're asking to judge their policies, their procedures, and what this person does. They like him. He's a good guy. How do you come in and say they're impartial? And once again, to give a window on that, what did Captain Cyber say? Because Captain Cyber, when we asked, we said, okay, you've been listed as a defense witness. Okay, what's the policy? If somebody's disarmed with a taser, do you have a policy on that? Nope. No policy. Never heard of it. Yet then he takes a stand in front of you and says, oh yeah, that's deadly force. Well, wait a second. 2 weeks ago, when the detective asked you about it, you said, no, there's nothing. But now that, as soon as somebody disarms you, oh, a weapon, that was a weapon. You never said taser specifically, but he was asked specifically about a taser and disarmament. Nope, there's no policy on that. We don't train nothing about that. But yet all of a sudden it changes. That gives you a window of why there's bias. There's a conflict of interest. That's why we have the state police in here talking about it. There's a conflict of interest to try and bring GRPD officers to judge on another GRPD shooting incident. They have every reason, just like anybody else. Just like a bank, you don't ask the people who were responsible for training what went wrong. But even then, and this is what I'm talking about, you can believe all, some, or none. They say Grand Rapids policies are generally accepted police practices. They're one and the same. There's no difference. Both of them say that. So that to create this, he doesn't know what generally police practices are because he wasn't trained on them. It's just a fallacy because it's one and the same according to GRPD. Now, the other example is Officer Gady. Why couldn't he talk to the officer? I got better things to do. He doesn't want to talk to an officer to give him, I'm not disputing. That's not a dispute. Yeah, when you use deadly force, that's what's trained. You use deadly force, you're going to shoot to kill. They're not going to try and shoot an arm off. They're not going to try and shoot a foot. That is, why do you want to talk to the detective about that? So he trains, he was part of his recruit class. It's somebody in-house. You can't ask somebody in-house to be completely impartial and unbiased when you ask them to do stuff like that. But when you look at it, when you think about it, when you try and compare in terms of what's going on between these experts, compare the experts, what about Sergeant, I think it was Johnston, the first sergeant on the scene? Let's remember his testimony. Remember what he said? Did he or did he not sound like Seth Stoughton? Because he was worried.
I think with his assistant prosecutors, that's how he's won cases.
I didn't know what was going on in that car. I didn't know what the individual that was standing outside the car had. He could have a gun. That's what we teach. We don't know what's going on. I mean, that's the thing. He's got 3 officers at the time, all with handguns drawn. And watch the body cams. How carefully they approach that car because they don't know. That's what they're trained. So it's kind of a contradiction in terms to say, yep, it's okay for a single officer all by himself to run after and chase and tackle somebody, which flies in the face of their policies that says don't do that you saw. That's a big difference there. How can you change if they're treating everybody, 3 officers on scene, being that careful? Why is 1 officer all by himself? That's okay. That's fine. And so it's not distraction. So what is the purpose?
The judge is watching Dr. Phil on her computer.
If it's just as many times you snap your hands, there's no totality of circumstances. It's just looking at that moment, period. And what's the purpose of the totality of circumstances? Looking how the officer got into that situation. There is no purpose. There is no totality of circumstances. Well, he was somebody had a taser, you can shoot him. And the interesting thing
What
was,
is he talking about?
Who did he say? Well, Professor Kroll. Professor Kroll is the one who said, "Oh yeah, they're able to use deadly force because he did that study." Professor Kroll isn't a taser expert. He has no idea of police policies. He said that was his testimony. It was his impression of police policies. Because they can't bond claim the GRPD officers, nobody can say anything about what the taser policy. There is no. Take a look at all the policies. Take a look at the policy where it says if you're disarming the taser, you can use it. You can shoot them. This is not there. There is no policy. It's based on the totality of the circumstances, based on everything the officer knew at the time. And what the officer knew at the time goes back to when the incident started. The whole thing, not just looking at that one brief second. And why would a reasonable officer, when there's been no aggression, there's been nothing, no punching, no kicking, no hitting, no anything, think he was going to die because somebody had his taser?
By the way, the banner, it's redirect.
And you're right.
Oh,
or
sorry.
You're right. Manslaughter is going to be brought up. And it was a complete misstatement of the law to say, well,
I hate when I do that.
Is not an intent to kill. That is not the law. Listen to the instruction. It is an intent to kill. The traditional manslaughter thing is when a spouse shows up and sees their spouse in bed and loses it. That's your typical manslaughter. You lose it and they want to kill them. It's not, well, they got in a fight. A manslaughter instruction is because of emotional excitement. Because of emotional excitement, somebody was driven to kill somebody.
That's not manslaughter.
It's not just, well,
he's misstating manslaughter.
Different thing. Manslaughter, listen to it. And because of emotional excitement to the point of
I
reasonable
can
person.
bet
That's
good
one
money.
factor, but that's not the only one.
I can bet money he has prosecuted a person who saw
Professor Blake.
a spouse in bed with somebody else and started shooting. Nana. The microsecond before they thought, oh, I should kill them both. That is enough for intent.
I think this case broke the prosecutor. I think so too.
But it's justified excuse. It reduces it to a lesser crime. Manslaughter is a lesser crime. So if you think this fight, if you think this battle, you need to characterize it as a battle.
Why then, sir, did you add manslaughter at the end of the trial? When he's so concerned about not being able to get...
dismissing the manslaughter based on his dosing.
He grabbed my taser and I'm tired.
He wasn't emotionally charged. He didn't catch Lyoya with his wife, so why did you add it?
And watch the video. Yeah, take a look at the video. Yeah, he stands up.
He's 100% misstated manslaughter.
He shoves him back down. He's got total control over this incident. So to think that he has to kill him at that moment is just wrong. It's not reasonable. Yeah, no reasonable officer would come up with that. And why? No idea why it's so far. Where's the fight? It's not a fight. It's a wrestling match. And that's the other thing that was interesting about GRPD puts the fear of God. Puts the fear of God about tasers. Yes. Watch that video. Watch the graduation video. This is the graduation video. So the fear of God, you put a serious, it's a serious weapon, but the fear of God is an instrument that you put the soundtrack to Top Gun to in the graduation video. And take a look, get a closer look. Look at the smiles. Look at the smiles on all their faces. Yeah, somebody's going through it again. It's taking the ride. We're talking about taking the ride.
All right, we got 85% not guilty in my chat.
I have 64% not guilty and 36% manslaughter. And none on murder.
I got 8% on the other two.
Something to be concerned about, sure. But this whole thing in terms of distractions, it is once again, it's amazing now because now we're saying don't ignore the defendant's prior statement, ignore it because it was just a police report. But we heard
really curious to see what comes out of this.
Mr. Dodge asked him, well, you've been 3 years. There's a lot going on in those 3 years. You've been through a lot of
The graduation video showed the guys getting tased. The Officer Schurr and his classmates getting tased.
So how do you determine what it is? You gotta take it. That's what the statement's there for. Compare what the differences are. Take a look what it is. Take a look. Where did the bladed stance come from? Because that's what it says written statement. Where's the bladed stance? Because we heard what the bladed stance was by Captain Sider. The bladed, somebody may have a gun. That was a bladed stance. No testimony to that.
Verdict in, prosecutors. I got so concerned when you're like, there's already a verdict because we're a little bit behind. I was like, no, there's not already a verdict.
So, what we're trying to do is trying to build up the danger of Patrick. Trying to build him up. He had a bladed stance. It was dangerous from the get-go. Well, then if it's dangerous from the get-go, why are you chasing him? And that's part of the totality of the circumstances. You think he may have a weapon, you shouldn't be chasing him. That's what GRPD policy says. It's a bad idea to do that. And you got to take a look at everything that led up to the decision to fire that shot. And simply getting up is not enough with the taser. He has gotten up 3 prior times and has done nothing. Has done nothing other than try and get away. But you're supposed to jump to the conclusion, using heuristics, jumping to a conclusion that he's going to kill you. That is not reasonable. It may reduce it. Maybe it's manslaughter, but it doesn't excuse it. It doesn't say, yep, go on away. You did nothing wrong here. So when you're looking at everything, yeah, it's a big decision. But a reasonable doubt, you'll hear, I've talked about it before, a reasonable doubt is a fair, honest doubt. But it leaves you firmly convinced. Firmly convinced based on the evidence. Based on the evidence that's presented here. I think when you look at this, when you look at the facts, when you look at the evidence, you should be firmly convinced that there was a homicide here, there was a murder. It was second-degree murder. It was a death caused by the defendant. He intended to kill, and there is no justification for it. Simply having a taser.
If manslaughter is on the table, the defense should ask the judge to remove it. Because clearly, nothing in the prosecution's case is about manslaughter. So it shouldn't be considered.
Is there enough factual circumstances for the jury to conclude that he accidentally fired the gun or fired it out of frustration or emotion? Maybe. And that's why it's going to stay on.
Yeah.
But the one thing where he said is it's happened 9 times where a person's actually been tased. An officer's actually been tased.
Especially with the defendant himself saying he didn't aim. Right? He said he didn't aim, so that actually might be enough to get the manslaughter to stick. This is a bad answer. That was a real bad answer. When the jury asks you, why'd you shoot him in the head, you say, because that was the only target, not because I didn't aim. Is he mentioning Trump? I can't even hear him anymore.
Oh, he's done.
He just walks away and grabs his pad.
Are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case.
Do we need to hear this?
Remember that you have taken an oath.
I don't need to hear it.
True and just verdict based only on the evidence and my instructions on the law.
Yeah.
Okay.
That's all we need to hear. Evidence presented and her explanation about the law.
Poll closed. 85% say not guilty in my chat, with 7% tied for second degree and manslaughter.
I have 69 not guilty and 31% manslaughter. Nobody had murder.
I must have had one person I think that did murder, and one person that did manslaughter. But it's a tough case, like I said from the beginning.
Yeah.
You could go either way. All right. So right now the jury is still out deliberating. We have no indication of any questions or anything coming back. I do have a verdict watch stream that I set up. It's on Nick's channel as well. And we're going to go live when we have a verdict or something substantial that's happening. I don't, I generally don't sit and just stream while we're waiting for a verdict. I don't know about you, Nick, if you want to.
I mean, if they go on tomorrow, I can do, I have some Judge Simpson to watch meanwhile, or Judge I have the it's
I set it up to go live at 5 p.m. today, but it's going to go live whenever there's a verdict or something, so
for fuck's sake.
Or if you want to do a verdict stream where you're just sitting and hanging out waiting for something, that'll work too.
I have it, but I can do watch Judge Simpson, not Judge Schroeder, but I mean, I follow a bunch of judges on YouTube, and I do the recordings of Judge Simpson.
Yeah.
So we can watch that if they are still going tomorrow. But I don't know when. I don't know when I get back from work tomorrow, because there are the people are having cold, the big C cold at work.
Oh yeah.
Yeah. So all of a sudden, it's like half of us actually working.
Well, I'm going to be in the office, and I'll be around tonight and tomorrow all day. And so if we get a verdict, we're going to go live with it, and we'll be available. But if you want to, you could stream Simpson and then go live with it. All of that good stuff works. I'm really interested to see what the jury comes back with.
Yeah. I'm not sure, because it all depends on that half second.
Yeah.
And even that could be, did he actually see the taser change hands?
He didn't mention in his report, did he?
No.
And he didn't mention in his report. Some of his answers were really bad. If we're basing it off of the closing arguments alone, I would say it's going to be not guilty. But obviously there's more to it than this. And I wasn't convinced on any of his innocence or justification rather, until the experts were really testifying. The defense experts were. So
again, I wish they ended with those two experts. Now, the last cop, he wasn't bad, but those two were excellent.
Yeah.
So
alrighty.
I'm going.
We have Guy Smiley, Taser Guy, on the way out. Nick, do you have anything else coming up other than some Simpson stuff and waiting for this verdict?
Not really. Every damn trial I have upcoming are at risk of being postponed. The Adelson trial postponed.
Yeah. Adelson's postponed. Too bad Diddy's not being televised, right?
Yeah. No idea. I can talk about the Melly trial, because Raven Liberty just did she filed a bunch of motions the past week about misconduct. And there is misconduct, which is stupid in that case, because had the prosecutors and investigators just had a little patience, it would have been a slam dunk case. But it seems like that Miami or that Florida-based prosecution are mentally unable to not cheat.
Well, I mean, they are a prosecutor's office, right? So so they start in that sort of camp.
This prosecutor here, he's a bit of a moron, but he doesn't cheat.
That's true. All the evidence. This was an evidentiary, clean case that we just watched. Now, whether or not the judge should have allowed the 2 out-of-state experts to pontificate about police procedures, at least the officer was, or the prosecutor wasn't hiding the fact. Everybody knew what was coming out. So it was a clean fight. I just think the prosecutor was on the wrong side of that fight. So, all right, with that, we will see you guys for a verdict. Thanks for sticking around with us. Thank you, everybody, for sharing with your friends and subscribing and telling others to do the same. And we'll see you guys. Hopefully, I doubt we'll get a result by the end of the day. But if we do, we'll go live.
Yep. All right. See you.
Salesman is the kind of guy you just don't mess around with. I see him passing by with his top hat on and his purple coat of velvet. My taser salesman is the kind of guy, he gets so excited when they call him in to testify. He says, yeah, I'm invited to show and tell all about the tasers that I sell in court. He's proud to give the word, he's happy as a songbird. My taser salesman has got all the toys, he's a big time vendor. If you want a high voltage device, he's the guy you should surrender to. The next time I got pulled over, the cop said out of the car, I said before you pull out your taser, you should talk to my lawyer who can show and tell all about the tasers that he sells in court. He's proud to give the word, he's happy as a songbird. The next time I got pulled over, the cop said out of the car, I said before you pull out your taser, you should talk to my lawyer who can show and tell